2023 CR 11510A and B and C present in the courtroom, attorneys for both the state and each of the three defense attorney teams, as well as the three defendants. Witnesses on the stand. The jury is not yet in the courtroom. Counsel, you wanted a 7:05 hearing, is that right?
Yeah, based off some of the things that she testified to on Friday, Judge, I think it's appropriate. It seemed like she was going to offer opinion testimony, and I wanted to explore that.
Okay, you may proceed.
Good morning, Detective Platt.
Good morning.
So on Friday, you made two statements that caught my attention. Number one, you said, "I know why they were indicted. I know some details." Those are two statements you said. Do you remember saying those statements on Friday?
Yes, yes, I do.
And you have not been designated as an expert by the state, have you?
No,
Okay. And you don't claim to be an expert in any particular field, correct?
no, I don't.
So what is your opinion? What he said, "I know why they were indicted." Why were they indicted?
For murder. I said that because it was on the news. Everybody on the department knew about it. Our office is aware of it. I mean, we wouldn't be here if they weren't indicted for murder.
Okay. What did you review, since you speak to the news and you're talking about other investigators in this case? What have you reviewed before you took the stand on Friday?
I haven't reviewed anything with the case.
Have you reviewed specifically Detective Soto's report?
No, I didn't read his report at all.
Have you discussed with him this case at all?
I did discuss with him the case.
What did you talk to him about?
Honestly, mostly just about our experience with Jason Goss on the last trial. That really is what I spoke about. Was I told him, be calm, because we experienced him on the last trial, and
I experience him every day.
well, that's really what we spoke about. I wasn't speaking about details.
Sure.
I was speaking about being in the courtroom.
But not so. I mean, and you're know you're under oath, and so no details at all. You don't know any details from the media, from Detective Soto, at all. Nothing.
No, the stuff from the media that I saw was not audio. It was being in the gym and seeing it come across the screen, something like that. I mean, I didn't watch or read full news articles on this.
May I be more specific with you?
Sure.
So, and Jason and I reviewed this before this morning.
Yes.
There was a portion of my questioning to you where I was giving you a scenario, and it was a general scenario.
Yes.
And you were answering as if you were talking about this situation. You talked about an obstruction, and I said that wasn't my scenario. Okay, so you're not talking about this case. So you alluded to knowing that there was quote unquote an obstruction or potential obstruction in this case. How did you come to that conclusion? Because
I took Sergeant Flores' statement, and he described the exterior. He described the porch. He described the window with no screen on it, with the glass door next to it.
Okay, and that's the extent of it.
I mean, yeah.
Okay, that's what. Thank you, Judge. Any further from anybody else? No, we're good, Judge.
All right. Ready for the jury, or?
Yes, sir.
Joe, you don't need this chair out here, do you want that? It's from last week when you were all down.
Yeah, I move it. Thank you.
question. Someone might already be there.
You're welcome.
Everybody has pins and their notepads.
All right, welcome back, members of the jury. Hope you had a pleasant weekend and a good morning so far. We plan to go through pretty much the rest of the day. I mentioned to y'all before that I do teach, so probably can't get out of here any later than 5:15 today. I'll give you a lunch break. If you need a break for any reason or can't hear for any reason, please let me know. All right, where we last left off, we're on cross, is that right?
Recross did, yes.
All right, you may proceed.
Thank you. Good morning, Detective Platt. Different trial lawyers have different styles. You understand that, right?
Yes.
And the reason why I say that is because I know it may have seemed as Mr. Cifuentes, and he knows I'm going to ask you this, he might have been a little tough on you on some of his questioning on Friday, right? Would you agree with that?
Yes.
But you understand that as lawyers that represent people and defend against the government, I mean, the stakes couldn't be higher in a case like this. Would you agree with that statement?
Yes.
And you understand that not only do we have a legal duty, but we have an ethical duty to zealously represent our clients.
Objection, Your Honor. Relevance.
This is my trial strategy, Judge, and I know he wants to try to control it, but I think I have little leeway. I'm asking for a little leeway.
Since she's actually arguing, we'll let him cross-examine instead of asking her questions.
All right, let's get the question.
Thank you, Judge. And one of the things that is reality is that these folks over here are trying to send these guys behind us to prison. You know that.
Yes.
Okay. And so, last week on Friday, the judge ruled that Mr. Cifuentes could ask you about a very challenging time in your life. Remember that?
Yes.
And there were some things that I heard that didn't really make sense, so I have to delve into that to clear them up, okay?
Yes.
Okay, thank you for that. And I didn't object to you saying your story because I wanted you to say your story. But everything that you told the jury about that situation when you were suspended, SAPD brass and the administration, to include the chief, heard all that through your lawyer. Would you agree with that? They got your version.
They did.
Okay.
Yes.
And I say this respectfully, but even though they got your version, they still decided to suspend you.
Yes.
And in that suspension, part of the thing you agreed to is that you would not contest the fact that there was a finding that you were not truthful. Do you remember that?
Yes.
But I get the feeling, and I'm happy to be wrong on this one, but I get the feeling that you don't believe that you were treated fairly.
Yes.
So is it safe to say that the brass, the administration, was wrong in your situation?
Of course, I believe that a certain person was wrong. I wouldn't blame the whole administration. I blame one person.
But nobody in the other part of the administration tried to stop this one person, did they?
No.
Okay. And so, at least the point I'm making is administration, brass, people that claim to know policy, just because someone higher up in SAPD says that the men behind me are wrong, doesn't mean that they're right. The administration.
For the administration. Say it again?
Just because the administration blames these men for doing something wrong on the night in question in this incident, doesn't mean that the administration in SAPD is correct.
Objection invades the province of the jury, Your Honor.
I don't know if that's a proper objection to this question, Judge. I'm asking her opinion on the administration. Jeremiah, please finish.
I'll overrule.
Thank you, Judge. So it doesn't mean that the SAPD administration is correct about these men either, right?
I mean, I don't know how to answer that. I don't.
Okay, let me make it clear to you. The administration, in your opinion, or at least one person was wrong about your circumstance where you were suspended for being untruthful. Remember?
Right, yes.
All I'm asking, is it possible that they could be wrong about these men also?
It is possible.
That's all I was asking, thank you. Now I want to direct your attention. Well, thank you, Jason. I mean, and in your situation, the reason why you feel that way is because they didn't look at your Coban situation and all the videos in your incident, correct?
Well, and if you don't mind, that I just add that.
Answer my question first, then I'll give you some leeway if
Okay.
you don't mind.
Yes, because they didn't review my Coban.
Okay. And so is it important, I guess, and I'm gonna get to this in a second. It's important for people, administration, prosecutors, detectives like Detective Soto, review all the videos in relation to the incident with these individuals, these men behind me as well, correct?
Some people, not all people.
Should administration and detectives review all the videos for the incident with these men that we're here for? Should they have reviewed all the videos?
Well, I'd say no, not all detectives, because I still don't believe as an assisting detective that I was required to review all videos.
And that's
So I just want to make sure that's clear. When you say detectives, are you...
Let me clear it up for you, because I
Yeah.
think that's a valid point. The lead detective, because I'm going to talk about walking warrants in a second. I need you to educate this jury for me, okay?
Okay.
Should the lead detective in any murder trial review all evidence before they make significant decisions?
Yes,
Okay. So now let's talk about officer-involved shootings, okay?
yes.
We use terms, and I think we all guilty of it, and we don't, doesn't necessarily mean that they understand the terms we use every day. Will you please explain to the jury what walking a warrant means?
Walking a warrant is when the detective writes the warrant and then you take it to the judge and get the warrant signed by the judge. That's just walking a warrant. It's that simple.
But why do you walk a warrant versus let it go to the grand jury and let a grand jury indict it?
The nature of the crime, if it's a severe crime against a person, if the suspect is a danger to others,
Well, that's where I want to get to.
there's
So
different
walking
reasons.
warrants, in all fairness, walking warrants really applies to gang members, people that are really dangerous to a society. Would you agree with that?
Those are some people, yes.
Well, how many, and maybe you don't know this, and if you don't, that's fine. Have you ever seen officer-involved shootings where they walked the warrant within hours of the incident?
There,
Let me ask the question again.
I know, but I'm not sure. I think I can say it, so I'll say it. But
I'm not sure. I don't know what you're going to say. Let me just ask the question very specifically because it's really kind of a yes or no.
it is. But what? And I'm sorry. I think it's okay. But there's another officer case, and I know a warrant was walked on that one. I just don't know the time frame. But that's the only other case that I know of.
Well, I'm asking. If you don't know the time frame, I'm asking about specific time frames.
Yeah.
Okay. So I'm just going to ask real specific questions. You testified last week. And I'm going to get your words because I want to make sure. A warrant would not be, if you were the lead detective, your quote, a warrant would not be walked within 24 hours. Do you remember saying that last week?
What was the question?
Your answer was, the question was about walking a warrant on a case like this as the lead detective. And you quote, a warrant would not be walked within 24 hours. You remember saying that?
I remember Mr. Harris asking me a question about warrants being walked within 20, but I just don't remember the rest of the question.
But do you remember saying that as your answer? Because I wrote it down and caught my attention.
I don't remember what the question was exactly.
But do you remember giving that answer?
I remember giving an answer similar to that.
Okay, well then let's
But
talk
a
about that
different
similar
question.
answer you gave. Well, one second.
Yeah.
Have you talked to anybody between Friday and today
About this?
about the case, about your testimony, about anything?
No,
Nobody at all. Have you talked to the state?
no,
Any representatives of the state?
no.
Okay. So you recall now giving a similar answer to what I wrote down as your answer of a warrant as a lead detective would not be walked within 24 hours, correct?
Like I said, I remember answering it's similar to that.
Okay.
But for the question when he asked me about if something along the lines of how many cases did I think that I have walked a warrant within 24 hours? That's all I'm asking is just to specify the question.
So Mr. Harris asked you. I'll bring it
Yeah,
up. Okay?
yeah. I mean, I'm not trying to argue. I really am not. I just want to make
That's up to
sure.
people's opinions, but I'm going to ask you the question because I want clarity for this.
Okay.
jury. This is Mr. Harris, how many occasions, have you, comma, sorry, we
Yes.
just wrote it down. have you, comma, how many occasions have you determined probable cause and walked a warrant within 24 hours? In my cases, it would have been an on-site arrest.
Yes.
Or the
okay.
warrant, let me finish, please. Or the warrant was not walked within 24 hours. Now, do you remember the exchange?
Yeah, I do. I remember that
Okay,
exact
so
scenario.
that was my original question. In my cases, you as the lead detective,
Uh-huh.
it would have been an on-site arrest or the warrant was not walked within 24 hours.
In the cases I've worked, yes.
That's what I asked.
I'm sorry.
That's okay.
I just wasn't understanding
Okay,
the full
I'll try to be
question.
more clear. But now, do you remember saying that?
Yes,
Okay, so in your cases, you have not walked a warrant within 24 hours. You remember saying that?
right, yes.
Okay. So let's talk about your experience as lead detective. As a lead detective, before you walk a warrant, is it important to review all the evidence before you go before a magistrate judge, have that magistrate judge sign an arrest warrant for individuals, and then those individuals be charged with something as serious as murder?
Yes,
And so, you mentioned that would be considering the totality of the circumstances, right?
right,
That's a term of art that we use in the legal system and you in law enforcement, right?
yes,
And you testified last week that the totality of the circumstances to you means reviewing all evidence and facts in the case before taking action.
yes,
You remember saying that?
Yes, I do.
Okay. So, if there were six, I'll just say this, since you don't know about this case, but if there were 6 officers, may I stand up, Judge?
Yes.
If the incident happened here on the porch, if there were 6 officers directly in front, facing the porch with their body cams, would it be important for that lead detective to review all of these 6 people before you walk a warrant?
I'd say as many videos as possible.
Now, let me ask you the question again. If there were 6 officers right in front of the incident with body cam, would it be important for a lead detective to review all these 6 individuals, maybe more, videos before you walk a warrant and ask the magistrate judge to arrest people for murder?
Yes,
And you've been involved in prosecutions as well, correct?
yeah,
'Cause you've testified for the government.
yes,
And would it be important for a jury? Would it be important for the government? Can I stand up again, Judge?
Yes.
To bring all of these officers standing right in front of the incident so a jury like this could see their videos and hear their testimony. Would that be important?
well, that's not up to me.
I didn't say it was up to you. Hey, listen to my question, please. Would it be important for the government to bring these 6 officers that stood right in front of the incident with their body cams so a jury can hear from them and see their body cams and they can make a consideration? Would that be important for them?
Yes,
More importantly, would you expect the government to do that?
I would assume so.
I would assume it as well. Okay, so if there is an officer Ramos, if there was an officer Vince Gomez, if there was an officer Travis Thompson, if there was an officer Dylan Young, if there was an officer Ricardo Neri, and if there was an officer Maria Salinas, as those 6 to 7 officers, we should hear from them. A jury should hear from them before they make an important decision. Would you agree with that statement?
Yes,
Pass the witness. Thank you for tolerating me. Good. Good. I think we're done. I think we're done, Joe.
All right, state.
We have no further questions, Your Honor.
The rules on the book, you know what that means?
Yeah, but I'd like this witness possibly subject to recall.
All right, you are subject to recall.
okay.
You're excused. All right, state, you can call your next witness.
State calls Karen Foster.
swear you in. Do you solemnly swear or affirm that you will make true answers to such questions that may be propounded to you?
Yes, I
Swear
do.
to tell the truth. All right. Can you introduce yourself to the jury and spell your name for the court reporter, please?
Good morning. My name is Garon Foster, Garon Foster, Foster.
All right. State.
Good morning. Mr. Foster, how have you made a living the last 30 years?
I was employed as a Bexar County forensic scientist for the last 30 years. I recently retired in February of this year. The last 18 years, I was a forensic scientist supervisor at the Bexar County Criminal Investigation Laboratory within our forensic serology DNA section.
Can you tell the jury a little bit about your education, your background, your training that qualified you for that position?
Yes, sir. From an educational standpoint, I received a bachelor's degree in zoological sciences from the University of Texas at Austin, a master's of science in forensic science from the University of Alabama at Birmingham. My entire career was with Bexar County, so it began with on-the-job training and then joining local as well as national and international organizations specifically within forensic science. Therefore, I was able to attend workshops to continue education in those areas. The educational requirements specifically in my area, which I had, was biochemistry, molecular biology, genetics, population genetics, as well as statistical analysis. A brief background then would be I hold a certificate from the American Board of Criminalistics in molecular biology. And then also while employed, I was licensed from the Texas Forensic Science Commission as required by law as a forensic analyst.
And in your 30 years applying your craft, has it all been here at the Bexar County Criminal Investigation Laboratory?
Yes, sir, it was.
And the lab itself, is it accredited by the Texas Forensic Science Commission?
Yes, the official accreditation comes from a different organization, but it is overseen by the Texas Forensic Science Commission. And yes, it is.
And as the forensic scientist supervisor, were you involved in making sure that the lab maintained the training and the protocols to stay accredited during the entirety of your time there?
Yes, sir, I did.
You had mentioned two things, serology and DNA. Can you tell us, first of all, about the science of serology?
Yes, forensic serology is essentially the examination of items of evidence that are biological in nature. You think of blood or semen or saliva, and then if possible to identify those items. And then if the identification of whatever blood stain or tissue is made, then determining if there is sufficient cellular material to conduct DNA analysis.
And when law enforcement agencies submit a sample to your agency to determine whether or not any biological material exists on an item, do you have certain protocols for accepting evidence?
Yes, the laboratory would accept the evidence as long as it's not compromised. Otherwise, for example, it comes in a sealed condition and it's submitted by a law enforcement agency to the crime laboratory.
And in the entirety of your time there, have you been accepting at your lab submissions by the San Antonio Police Department?
Yes, sir, we have.
And with respect to DNA analysis, can you tell the jury what DNA analysis is and when it's done?
Yes, well, very briefly, DNA, or deoxyribonucleic acid, is a biological material. It's located in almost all of the cells of your body. It's inherited from your mother and your father. Its ultimate reasoning for being there is to help code or tell your body when to turn on certain proteins. And the DNA itself is the same in all of your cells. And my DNA is very similar to your DNA. We all need the same proteins or enzymes, basically our genetic makeup, but a small portion of it is different, or we call that polymorphic. there are different sizes of the DNA in small percentages. So 99% of my DNA is the same as yours. But that small percentages that's different, a forensic DNA analyst will examine those areas, and if sufficient DNA quantity and quality is available, create a discriminating profile to help determine who may or may not have been the donor of that biological fluid or stain.
I want to ask you about a submission under your lab under the number 23-03995. It was submitted to your lab in September of last year. Do you recall having any involvement with any testing from that submission by the San Antonio Police Department?
Yes, sir, I do.
And what were you asked to do in the initial submission on September, or around September 16, 2024?
Yes, I received 4 different apparent bullet fragments, and I was asked to examine those for the possible presence of blood or any other tissue that ultimately would potentially lead to a genetic profile if there was biological material on those items.
All right. And is that an unusual request, or is that fairly routine?
It's fairly routine.
Okay. If I can approach her.
Yes.
I want to show you what's been marked as State's Exhibit 157. So take a look at that. Do you recognize the packaging and any of the markings?
Yes, sir, I do recognize the packaging.
And how are you able to do that?
Well, I'm able to do so because I see my initials and the date in which I made this examination, as well as the unique criminal investigation laboratory number in which you had referenced.
And when did you first see this package?
I would have seen this package on September 13th of 2024.
And when you first put your hands on it or so, was it in a sealed condition?
Yes, sir, it was.
And inside it, what was inside that package when you opened it?
Well, inside this tape-sealed envelope were 4 smaller tape-sealed envelopes, and each one of those would be marked with a law enforcement agency number and brief descriptions, and then each one of those would be opened, and that is where the alleged apparent bullet fragments were found.
Let's take a look inside. And emptied the contents of State's Exhibit 157. Does it indeed contain the 4 envelopes that you described?
Yes, it does.
Looking at those 4 envelopes, do you again recognize those by the markings and the packaging?
Yes, I do.
And are these all the 4 bullet fragments that you examined upon the request of the San Antonio Police Department for the presence of any biological material on any of these bullet fragments?
Yes, that was done.
Okay. And tell us how you began to approach this issue.
With identification of any item is first basically a visual examination. Notes are taken as to the packaging materials and then whatever's on the inside of that packaging. So for example, in this case, there was small deformed bullet fragments, and visually I would look at that for, in this case, the presence of blood. You can think of a reddish, brownish type color. And then certain chemicals could be added to this, and it's a chemical color test that looks for the presence of blood. And then visually, you're also looking for non-blood tissue. I mean, for example, if there was tissue on something that had muscular or fatty tissue, all of us have probably seen that, whether it's maybe a chicken or a steak or something maybe small that you've eaten, or even a scab on your body. These are just various tissues that you can visualize and see. So the chemical testing would have been performed and a visual test would have been performed. And then the last test basically is just the collection of that biological material. So for example, a sterile swab, like a Q-tip swab, would be taken. Sterile water would be placed on that, and then the bullet fragment would be actually swabbed itself. So we'd remove any potential biological material onto the actual swab tip.
Okay, and you did that here on all 4 of those samples?
Yes, sir, that is correct.
Do you have a person in your lab that you're familiar with named Holly Warden?
Yes, I do.
And how is she employed at the lab?
Holly, at the time, I believe, was our forensic scientist supervisor in our firearms section. She was a longtime forensic scientist, and right around this time, if I recall, she was becoming a supervisor in our firearms section.
And do you recall making arrangements with her with regard to this testing to do your testing before she did her testing?
Yes, that is correct.
Okay, and why would that be?
Well, traditionally, if we're going to be examining an item that maybe another section in the crime laboratory is going to be handling, it's just better practice for us to remove any of that, for example, biological material from, in this case, a bullet fragment before another scientist handles that bullet fragment and begins doing their types of analysis. Basically, we don't want any of an additional person's DNA to be introduced onto this fragment, and we don't want to lose any small or potential biological material while another scientist is handling that item.
Okay. Now, with respect to the 4 bullet fragments that you tested that are contained in 157 A, B, C, and D there, did you find any biological material on any of those bullet fragments?
No, I did not. So visually, I was unable to identify what appeared to be blood or any other bodily tissue or stain. And then a chemical test, just looking for the presence of blood, was performed, and that was also negative on all 4 items.
Okay. So when you get that kind of finding that you can't find blood or biological material on it, does that mean that DNA could not be present on those items?
No, it is possible for DNA to be present in, for example, saliva, but I may not be able to visualize saliva. So it is possible for DNA to be present in something other than a visual blood stain.
So when you did your serological testing on these 4 items, and you swabbed each one of them, right?
Yes, sir, that is correct.
You retained those swabs for later DNA testing?
That is correct.
Okay, and you repackaged these bullets, fragments, in each envelope, put them back in the larger envelope?
That is correct.
And then did you seal it?
Yes, the envelope itself would be sealed. The individual smaller envelopes, as well as the larger envelope, would be tape sealed with my initials and the date in which I did the sealing.
Okay, and then would the item be routed back to the San Antonio Police Department for them to preserve and protect thereafter?
In most cases, yes. In this case, it would have been transferred to our firearms section,
Yes.
so that Ms. Warden could do her analysis of it.
Thank you. Let's put these back together. Thank you. All right. Before you ended up doing any DNA testing on those items, on the swabs from those items, did you get an additional item to test?
Yes, sir, I did. I got one more envelope at a later date asking me to do the exact same analysis.
Okay. I want to show you what's been marked as State's Exhibit 155. Have you seen that before?
Yes, sir, I do.
And how do you recognize it?
I recognize it again with our individual criminal investigation laboratory number. I do see the date as well as my initials and an item number that has been given by the crime laboratory.
Okay, and that envelope itself, what would it contain?
Inside here also would contain a smaller envelope, and inside that envelope would have been whatever item I was examining. In this case, another bullet fragment.
All right, let's take a look at night in there. You have removed an envelope that is marked State's Exhibit 155A, correct?
Yes, sir, that is correct.
And on the back of it, it has an E1 written on there, is that right?
That is correct.
Okay. And looking at this envelope, does this contain the bullet fragment that you were asked to identify if it had any biological material on it?
Yes, it does.
And you conducted the same examination. Did you find any biological material on that item?
No, so otherwise chemically it was negative. Visually I didn't see anything, but should there be any material that cannot be seen visually or tested chemically, a swab was taken as well to collect any potential biological material. But in essence, we would say all serological testing was negative.
If a bullet fired by a firearm passed through a human body, would you expect there to be any biological material left on the bullet?
The possibility exists, yes, but there's absolutely no way, as a forensic DNA analyst, I would be able to state that it would or would not. For example, I can only say that if there's biological material present on the items submitted to the lab, and then if a DNA profile is available, who that may have come from. But how the DNA got present onto an item, I would not be able to say. And that would be included in, could a bullet pass through an individual and may contain biological material based on various variables, as well as could it pass through a person and not contain biological material. Both of those are possible.
Is it also possible that a bullet that passed through a human body and was submerged underwater for a period of time would not retain any of that biological material?
Yeah, that would be possible as well if water was utilized to wash away biological material, in essence.
Or if a bullet that was fired through a human body went also through other items, like a wall or something like that. Is it possible that any biological material on that bullet could have been, in a sense, wiped away by the subsequent items it struck?
Again, the answer would be, it is possible. Again, without being able to determine how DNA is present on something, but know that DNA can be introduced as well as removed from an item through, as you mentioned, water or mechanical removal. As to the bullet, again, if it passed through an individual, I'll be unable to say that. So the answer to the question would be, it's possible.
Okay. You had mentioned that you had examined these things visually. You put some chemicals on it to determine the serology, if there was any human or biological material on these items. You did not find any. You swabbed each of these items, the 5 items that we've shown the jury here today, right?
Yes, sir, that is correct.
So in a matter of time then, and you can tell us when, did you go back to the swabs on all these items that you looked at and examined to determine whether there was any DNA that could be detected on any of these swabs?
Yes, that's exactly what I did. I went and collected the swabbings that were made at or around the time in which I examined these a few weeks prior, and then attempted a DNA profile on each one of the swabs while these alleged bullets had already been submitted to the firearms section.
Okay, and how did you go about doing that with the swabs?
Well, DNA analysis itself involves 4 steps. The first is to extract any DNA that's present. The second would be to quantitate the DNA. So, for example, each one of these swab tips would have been subjected to various chemicals that are going to open up the cells that we have the DNA in. You can almost think of it as an egg that's being cracked open. And then we have a technique that quantitates DNA. How much DNA is present? Is it human DNA? And what is the quality of DNA? So that's the second step in DNA analysis. And if DNA is present, or it's believed to potentially be present, then the remaining steps are done. Third step is what we call polymerase chain reaction, or it's the amplification of DNA at various genes. These are the areas that may be different from person to person. And when I say polymerase chain reaction, it's almost like a photocopy machine for genetics. It amplifies over and over because DNA is very limited. And then the last step is DNA typing, which is the actual creation of the genetic profile just based on the various lengths of DNA that are polymorphic. The differences between you and me.
And what were your results with respect to each of these 5 bullet fragments that you tested?
In general, it was negative. Otherwise, either no human DNA was identified on those swabs that were taken from the bullet fragments, or if there was any DNA present, it was beyond any detectable limits of either the quantitation or going through the procedure and trying to attempt a DNA profile. So otherwise, no profile was available on any of the bullet fragments.
So in essence then, with the 5 bullet fragments you found, or that were submitted to you for testing, you cannot say whether or not any of them passed through a human body. That's fair to say?
It is fair to say, regardless of the DNA results, I would not be able to say if a bullet fragment had passed through somebody or not, but it's also fair to say that there was no human DNA that was identified on these items.
Thank you, Mr. Foster. I'll pass the witness.
Yes.
Mr. Foster. Hi.
Hello, Mr. Goss.
How are you doing?
I'm doing well. Retired.
Yes, no, I was going to tell you congrats on a well-earned retirement. You and I, we know each other. It seems like the most memorable cases I've ever had, you were a part of them somehow, and I've always appreciated that. I appreciate your testimony today. I'll just say I think you were fantastic at what you did, and I'm glad that you're able to retire and put that up. I did have just a few questions. Not really much. I think that you could say that some of your testimony is that really there's nothing that you have that you can offer that really tells us one way or another what happened as far as the bullets are concerned. You agree with that?
I would agree with that.
Yeah, and I guess testing for the biological material, one of the things that I think you said was that you may have found that there may have been some, but it was not even enough that you could figure out, like for instance, if it was male or female DNA.
That is correct.
Right, and because one of the things about, and you educated the jury well, and I just want to talk a little bit about kind of like categories, like you would agree with me that when you're testing, one of the early things that you can see is like, is this a male or is it a female? Because it's XX or XY, right?
It is, that is correct, but it depends if you're talking in a quantitation stage, and then there's additional testing that actually is the genetic profiling. And it is possible that one may not, or you may not be able to tell from a quantitation if it's male or female, because it could be in a background level. So regardless of the results, you may not be able to say male or female. But definitely when it came to genetic typing, that is the last step. If there is potential biological material, if there was male or female DNA present.
And the reason I ask that is, I think one of the things you guys can rule. For instance, you have a profile, but you also need to go get a known standard from different people that may be involved in the case, so that you can compare a profile to that known standard.
That's correct. So if you're asking, if I create a DNA profile from a crime scene sample, let's say blood that's identified on the floor, and we're able to see this is male or female DNA, and I have a profile, the question is, well, who may that be from? So when he mentions a standard, an individual will provide a buccal standard. So otherwise, if I had a swab, I can place it in my mouth. That's just the term buccal. And this known swab is used at that known DNA. If the individual is deceased, then it may also be a buccal, or it could just be a blood sample taken. But that would be the known standard compared to, for example, in this case, the bullet fragments.
Right, and so if you were able to get a profile, the way the known standard works is you get an unknown profile if you were able to get one off the bullet. And then you get a known standard, and then, I mean, this is simplistic, but you can compare them and see if they actually, if those two things match, or if they don't, right?
That is correct.
And I bring it up to say that in your 30 years, you would agree, and even in my 15, but in your 30, you would agree that that DNA, being able to extract and being able to get a profile and get DNA out of a substance or out of material has come a long way.
That is correct in two ways. One, we've become extremely sensitive in what we were able to detect based on the procedures themselves. And the second thing is we've become extremely discriminating. So if there is DNA present, discriminating, who may or may not be the donor of that.
Right, and I remember, I know that we had a case that had been running like 07, and the profile was it was really hard to, and we don't have to go into the detail, but it was really hard to see. And then when you reran it about 10 years later, 15 years, or 12 years later, for a case, you were able to get just basically a lock solid profile, and you could see exactly who that DNA belonged to.
Or another way of stating that is that today we need less DNA than we did in 2007, and then today we're looking at more genetic markers than we were in 2007.
Right.
So yes, a more discriminating, thorough, or a full profile would be available today.
And I make that point to say that even with all of that we have today, because you did your analysis in 2024, even with all of that and how sensitive it is, you weren't even able to get, using those state-of-the-art tools that you have, you weren't even able to get a profile off of any of these bullet fragments.
That is correct.
Right. So that would tell you, because honestly, something that's microscopic, like a microscopic drop of blood, you could probably pull a pretty good profile out of it.
It's a cellular-rich stain, so typically the answer would be yes. I wouldn't be able to say how the blood got there, but yes, if there's a sufficient cellular material in a small blood stain, yes, I would expect if the quality was present to be able to get that profile.
And yeah, and just going back to it, so ultimately in this, I think what you said with Mr. Lunan is that there's no way on the bullets that you analyzed, using your discipline and using your expertise, there's no way that you could say whether or not those bullets passed through a body, right?
That is correct.
And, I guess even if you did find it, you couldn't necessarily say that it passed through a body, right?
That is correct. Let's say that there was an item of evidence, a bullet fragment, that was on the ground, and it was maybe in a pool of blood sitting there, and that was submitted to the laboratory. I may be able to probably create a genetic profile from that and make a comparison. But as the scientist, if you ask me how that blood got under the bullet, I wouldn't know that it was sitting, in a pool of blood, but I definitely wouldn't be able to say that it absolutely got there because it did or didn't pass through a body. I would just say that, well, it was in a pool of blood, so therefore it's obviously possible for that blood to transfer onto it.
Sure.
So it kind of comes down to the how did DNA get there, would not be able to say.
Absolutely. And so as far as the whatever you did analyze, you would agree that you took whatever they gave you and you were willing to analyze whatever they gave you.
That is correct.
Right. And so there wasn't a thing where you were like, no, I'm not going to analyze those bullets or those, I'm only going to do these. You would have taken whatever was submitted to you, you would have done your job and you would have done your best to try to get a profile.
If time and resources allowed, the answer is yes. We would do whatever it is that would be asked.
Thanks. I'm genuinely glad to see you again, and I hope you have a good retirement. I'll pass the witness.
Thank you, Mr. Goss.
Good morning, Mr. Foster. How are you?
Fine,
My
thank you.
name's Monty Del Prado. I just have a few questions for you. Regarding this case, I think I got down what you said. So basically, your visual inspection of all 5 of these bullet fragments indicated the presence of no blood. Is that correct?
Visually, I was unable to see what I would expect to be blood, and then chemically was able to confirm that either blood wasn't present or it was below any detectable limits.
Okay. And the same question for bodily tissue. Your visual inspection of all 5 fragments, you didn't visually detect any bodily tissue.
That is correct.
And going that step further, your chemical testing of that indicated no bodily tissue. Is that correct?
If the bodily tissue was blood, that is correct. But if it was not blood, for example, something that you couldn't be seen with the naked eye, like saliva, we were able to confirm that with a very specific human DNA test. Would I find DNA present if there was human DNA? And those results were either negative or very limiting, beyond any kind of detectable limits.
Okay, thank you, sir. And with regard to the source of the DNA, the DNA on this bullet fragment, if the scenario were such, would it be fair to say that the DNA, even though you couldn't quantify it or qualify it, could have come from a person handling that bullet? Would that be fair to say?
I'd have to say that anything is possible.
Right.
Would I expect DNA from somebody's fingers to be present on a bullet as it passes through a gun and there? We're getting out to the realm of, well, it's getting closer to be not likely. However, it would be wrong for me to say that I absolutely could say that there would not be DNA present. So I have to answer that with, it's possible.
Okay. So, the sources of the DNA could be potentially innumerable if it's going into, like, let's say an apartment. There may be loads of DNA in a living area or in a kitchen area from the people that are residing there. Would that be fair to say?
Yes, sir, that would be fair to say.
Okay, and would it be fair to say that it might even be the DNA from the people who occupied that apartment before the current occupant of the apartment? I mean, that DNA could still be present from the people who were there before. Is that fair to say?
I mean, if there was biological fluids or stain present from the first individuals, then yes, it would be fair to say.
Okay, and I guess my last question is with regard to any water. If there were water, well, first of all, on the floor of the apartment could have potential DNA, correct?
That is correct.
Okay, and if there was water, like a line busted, and you've got the water coming out from a municipal water source, and I understand that, you know, the water is going to be treated with fluoride, but studies show that even there can be DNA fragments in even municipal water supplies. Is that correct?
I'm not aware of human DNA fragments in municipal water at any kind of detectable levels because we've used regular water as a negative control. Otherwise, we've gone through the entire process with water that maybe we've purified and have not identified human DNA.
Okay, but that was water that you purified, correct?
That is correct,
Okay.
but I will answer again that I'm not aware of any human DNA in any kind of detectable limits that would be in municipal water from a city. That would not be right for me to say that there is or is not.
Okay, and there was nothing detectable here?
That is correct.
Okay. Thank you very much, and congratulations on your retirement.
Thank you, sir.
Very brief. Mayor Butch
Yes.
or Mr. Foster. Not much left for me to ask after the first three lawyers, but I wanted to get some clarity on some dates. I know you were kind of later into this case. As far as submissions go, the lab tests items when they are sent in by an agency, right?
That is correct.
And so in this case, Detective Soto ostensibly is in charge of submissions to the lab as he sees fit, right?
I believe he was the detective at the time responsible, but yes, he or another individual would be responsible for deciding what items of evidence are sent to a crime laboratory.
And when those get submitted, right? As far as the
I believe
time.
so, yes.
Okay. And so that's what I wanted to get some clarity on. So you received a total of 5 bullet fragments for testing, correct?
For DNA analysis, that is correct.
In your section. And so I want to get the dates right here because there's 2 different submission dates for your section for testing for the bullet fragments, right?
That is correct, sir.
Okay, and so the first one, do I have it right that September 12th of 2024 was the first submission your section received in this case?
That is correct.
Okay, so we'll do first DNA was 9/12 of 2024, and so that's over a year after the offense date in this case, correct?
I'm not aware, I don't recall the offense date at this time.
If I told you it was June 23rd of 2023, that would be more than a year prior to the submission to your section, right?
That's correct. It's about 14, 15 months.
Okay, so we'll stick it here on the demonstrative states 184. And Ms. Warden helped me kind of walk through the same dates here. So that's the first submission. And then you get a second submission, do I have it right that that came on September 30th of 2024?
Yes, sir, that is correct.
Okay, so I'll put second DNA, we'll do 9/30/2024. And when you get these fragments, does your section sometimes identify fragments with an SAPD evidence number?
Yes, it will always be associated with whatever law enforcement
Okay.
agency number there is.
And so for the first submission, September 12th, there were a number of SAPD numbers that correspond to the fragments that came in, right?
I'm only aware of one San Antonio Police Department case number.
Oh, the case number, I may have misspoken. So is there sometimes a evidence item number that's referred to?
Yes, so the San Antonio Police Department or any other law enforcement agency, they may have their own numbering identification. it's not uncommon to start with an E, for example, say E1, E2, E3. Now, that may be different than the laboratory's numbering system, but yes, it is customary for them to have that.
Okay, and so if a bullet fragment was sent to you that, say, came from autopsy, that would have some corresponding number with it, correct? Like that evidence barcode number?
Yes, I would fully expect the law enforcement agency to have that barcode associated with it.
And we talked about the order of testing. If a year prior, Firearms and Tool Marks had done testing on a bullet fragment, that would necessarily compromise the potential availability of DNA evidence, wouldn't it?
It would be possible, yes.
Okay, and because, and you may know this, in firearms, they handle the fragments, right? They may even clean them off.
Exactly. They do handle it, and if they're looking for the individual markings on the bullet, the striation marks, the possibility exists that may need to clean them so they can visualize them.
Okay, so if we had a submission in September of 2023 of a projectile, and that testing was done a year later, you would expect that that could influence what DNA you may or may not find.
If somebody else had handled the bullet, as an example, and possibly cleaned it, then the answer is yes, that would be possible to affect the results that I would receive.
And I'm not casting aspersions on the section, you just rely on the evidence coming in the order that it's submitted, right?
That is correct.
Okay, and so as far as Detective Soto's submissions go, you did not receive any swabs for, say, a fire alarm closet that you're aware of?
No, sir, I did not.
No swabs for a security door?
No, sir, I did not.
No swabs for a steel lockbox?
No, sir.
No swabs for fire alarm batteries, right?
No, sir.
No swabs for some kind of fire ignition implement like a lighter?
No, sir, I did not.
And no swabs for electrical wiring?
No, sir, I did not.
Okay. And just to, the last question, to be clear, we had 5 projectiles or projectile fragments, not 16, right?
That is correct. There was 5 that were submitted to the section in which I was responsible for DNA.
Submitted by or at the direction of Detective Soto with SAPD?
Yes, sir, that is correct.
Okay. That's all I have. Thank you, sir.
Thank you, sir.
No further questions?
All right, the rules would invoke. If you don't mind grabbing the evidence and put it up on the registry board.
Yes, sir.
Yeah, he can relate to
Yeah. Yes. we're going to take up a matter outside your presence. It may be a while, so while we're doing it, we're going to go ahead and send you to lunch. Be back no later than 12:30. All right, enjoy your lunch.
All right, please. Please be seated.
All right, what do we got?
Judge, defense's motion as to objection of evidence in the matter.
Well, Your Honor, we provided the court copies of all the pleadings that are relevant in this case. One of the first things we did is we filed a notice of appearance where we, in our notice of appearance, shortly after this case was indicted, we requested under 3914 all experts. The state has failed to timely disclose any experts. I don't know that the witnesses A through E would be considered experts, but they didn't file a notice of witnesses until October 1st of this year for those witnesses. And as we've articulated, none of these witnesses have been designated as experts, and therefore, under Rule of Evidence 602, their testimony would not be based upon personal knowledge, and if they're not based upon personal knowledge and they're not an expert, they wouldn't be relevant. So the evidence should be excluded under 602 in the failure to meet the 3914 requirements of proper notice. And expert testimony is irrelevant if it's inadmissible. And we cite a case there. Also, additionally, we are objecting to any evidence as to alleged policy violations. I think we've made it patently clear in our motion and our pleadings that any punitive violations would be irrelevant because of the lack of causation. Under Texas Penal Code Section 604, it's essentially you have to show that a cause is sufficient in itself to cause the result. There's no way that they can show any policy violation caused Melissa Perez to engage in an illegal deadly assault with the hammer. And therefore, the need for self-defense was not caused by a policy violation. And although we haven't cited it, what's clear in the Supreme Court has rejected the Ninth Circuit officer-created danger, and that's been reaffirmed in Barnes v. Felix, which was cited in Judge Bemperod's order. So policy violations should not be allowed, and the court has previously ruled that policy violations should not be issues before this court. Additionally, one of the alleged policy violations is based upon our review of discovery provided by the state. There was a course given by Sandoval in 2022 that they're relying upon. It was not even a certified TCOL course at the time. It did not become certified until June of 2025. So at the time, it wasn't a certified course. Moreover, one of the captains that addressed this issue said there's no policy on barricaded subjects who are engaged in criminal activity and who are not alone. So even Sandoval's course, which was given in 2022, gave instructions about an alleged tactical retreat when there's no requirement in the law to engage in a tactical retreat. And the course that he gave in 2022 only required or suggested a tactical retreat when the person was non-criminal and alone and not a danger. None of those predicate facts exist in this fact situation. And so, since the predicate facts don't exist, since the course was not even written policy, it's an instruction, and it wasn't certified, Sandoval's course should be irrelevant. And again, the failure to engage, the putative failure to engage in a tactical retreat did not cause Melissa Perez to attack the officers. And it didn't give Melissa Perez the right to resist arrest or use deadly force against the defendants. Additionally, we would cite the court to document 71, page 11 of Judge Bimperod's opinion. What they're essentially doing is trying to have their cake and eat it too, because what they're trying to say is that policy violations resulted in the excessive use of force. And Judge Bimperod talks about how the plaintiffs, in that case, Manel's claims, were disposed of because there was no underlying constitutional violation. And essentially, a Manel claim is that a lack of policy or a failure to train or adherence to policies is what caused the result. And what Judge Bimperod said is that in prior summary judgments before document 71, the federal court dispensed with that. So what we're going to be doing, if you permit that inquiry, is to have a trial within a trial of something that's already been disposed of, and there's a lack of causation, there's lack of relevance, and it would cause confusion in the jurors. And we believe that it's not relevant, number one, but when you weigh the prejudicial value and the probative value under 403, it clearly does not require admission into evidence. And also, the barricade exigency is something they're attempting to do. And I told you previously that Captain Angel Costello, I didn't use his name, he wrote in an official SAPD document that was provided in discovery, there is currently no written policy on the specific disengagement of criminal barricaded subjects beyond the 5 Cs, which is what Thomas Nisbet has elicited from witnesses so clearly and distinctly and unrefuted. And so to inquire into barricaded subjects and exigency, even though the training does not require a tactical withdrawal, would be misleading. Now, in essence, this case is an attempt by the state to circumvent the court's ruling that's been made in trial and that was made in the motion in limine that the Castle Doctrine does not apply. The state has objected to any reference to grand jury, but we can provide the court copies of what has been provided to us in grand jury by the state. And what's clear is that any attempt to get into the Castle Doctrine is a repeat of how the state misled the grand jury that the Castle Doctrine applied and gave Melissa Perez the right to resist the officers' attempts to arrest her. And we cite in our pleading here that to permit this inquiry would essentially enable the state to violate Texas Rule of Professional Conduct 3.03. And there are cases that say that the rules of professional conduct set forth the minimum standard below which no attorney may fall. And so to permit the state to misrepresent the law, which they've already done before the grand jury, to represent the law in front of a jury would be improper, and this court cannot sanction or enable that. I don't know if Mr. Voss has any further information to add, or if Mr. Nisbet does, but we would urge that these witnesses, Nathan Sandoval, Melissa Campos, Nathan Herblert, Mark Bolter, and Captain Stephen Torres, be stricken from the witness list, and they not be allowed to testify in the areas that we've outlined.
Yeah, we would agree with this.
Judge, I'll respond after Neil does. Thanks.
Okay. First, Your Honor, I note for the record that a state's amended disclosure of expert witnesses was filed with the court on September 8th of 2025. In it, it lists 10 putative expert witnesses. Does include Officer Nathan Hurlbert, Nathan Sandoval, etc., well in compliance with the rules and notice. October 1st was just the general witness list, and I will simply say the state has met and complied with the statutory requirements for notice. As to the course that the defense is referencing, it is a class and training provided to all officers going into calendar year 2022 about, and that course has been obtained by subpoena on both the parties. We all received it at the same time. If you may recall, when the city attorney was in our last pretrial motion, this is the matter in which she wanted to have a protective order so that the evidence, so that the course materials be returned to the city at the conclusion of this matter. In that class, it discusses issues of barricaded subject, both criminal and non-criminal barricaded subjects. It directly addresses instruction given to all officers. The training records of all officers cite that they attended this course in the defendants in calendar year 2022, and it goes to their prior training and expectations of how they should apply that training in a tactical situation such as the facts at hand. The court has ruled, and we have not mentioned anymore 941, but the facts, it is clear, as the jury has already seen, it occurred at night. She was in her home. It is replete. I don't know another way to get around that. And this training, which goes into reasonableness when they have to decide, it adds context for the jury to receive that evidence. The second, Judge, the counsel continues to make reference that the state in its grand jury presentation misquoted the law. I can make the court aware. One, it was what went in, it was provided, as well as transcripts from witnesses that came forward. They all have that. I'm looking at the presentation. I will have to ask counsel, could you refresh my recollection? What is the illegal thing that I told the grand jury?
Your PowerPoint slides, I believe it was probably slides 43 through 49, where you quote the Castle Doctrine statute in your slides. That clearly is a violation of the ethical rules because you misstate that the Castle Doctrine applied to Melissa Perez, and you implied that in eliciting the testimony from the witnesses.
Your Honor, I am looking at the charts presented. I presented them instruction on 932, 933, as reflects the defendant's conduct, and I am citing the statutory Code of Criminal Procedure 1404 and 1405. I make no reference to the Castle Doctrine, which is a subset of 942, which has been discussed ad infinitum. I believe counsel would not accuse him of intentionally misleading the court. I believe he is simply mistaken in his assertion. Now, as to why state's expert Sandoval, who they received notice of, and his instruction, it informs the jury, and perhaps I will ask counsel, he articulates it better than I can read his notes, Mr. Lunan.
Your Honor, the importance of Nathan Sandoval's testimony about the training that he had trained each of these officers in about the tactics involved in these goes to inform the jury as to the reasonableness of their belief. You know, we have to prove that the defendant's perception of the threat was reasonable, right, on deadly force, and that goes to their subjectively, whether they believed it personally, and it goes to the objectively, whether the community standard and ordinary and prudent person would have also felt the same way, right? I mean, that's what a reasonable belief is. It's both the objective and the subjective. What the training does is it shows the jury how their minds were influenced and their policy and their directives and what they were held to do informs as to their subjective belief as to whether or not their behavior was reasonable. And so there's nothing more other than calling the defendants as witnesses themselves, which we cannot do, to talk about people that told him this is what the policies are, this is what the scenarios are, this is how you should respond to that. So it's very relevant for the jury to inform them about what their belief is, whether it's subjectively reasonable or not.
Again, they're missing the point that what they're trying to do is espouse a theory of officer-created danger, and what the Supreme Court has done is they've rejected officer-created danger, and essentially, by rejecting officer-created danger, what the Supreme Court is saying that 6.04 of the Texas Penal Code is applicable to whether or not the officers caused the illegal conduct by an accused. And so since 6.04 says that the cause has to be sufficient to create the result. And so when the Supreme Court has said officer-created danger is not a theory that the state can rely upon, there's no causation. We know that Melissa Perez attacked the officers with a hammer. We know that it's a deadly weapon. We know it's imminent because of the testimony. And so what the state is attempting to do is to say the defendants caused Melissa to engage in illegal conduct. So 604 says that's not relevant, and the policy is not a statute. There's nowhere in Chapter 9 does any provision say that if an officer violates policy, that policy means that they acted unreasonably and they lose their right of self-defense. In fact, if what the state really is saying is policy controls, what we know is that under 501.07 of the SAPD General Manual that talks about the use of deadly force, and I believe we used the metaphor that a steamroller beats rock, paper, scissors. And what they said, and what even Deanna Plott said, was that when your life is in danger, you use any means possible to save your life and the life of fellow officers. And that's what 501.07 says, to use any means possible. So, any means possible is, as we said, the steamroller that beats rock, paper, scissors, and rock, paper, scissors, or any other policies that may exist. So when your life is in danger, it doesn't matter that you violated policy, you are entitled to defend yourself or to save the life of another officer. It's not probative, it's not relevant, it's confusing, and it's a backdoor way to mislead the jury. And counsel may say that they used provisions from the statute, but the slide in question, and we can provide it to the court, the slide in question cited the counsel doctrine and the right to use force to defend property. And we can provide it to the court if need be.
Thank you, Judge. I want to address Mr. Lunen's counter-argument on the issue of an expert, I'm going to use their quotes, offering an opinion, okay? So, Judge, we would put before the court that an officer like Hubert, an officer like Sandoval, has no personal knowledge, was not at the scene during the incident, and is therefore only coming in to offer an opinion, okay? Which the court needs to understand that puts them in a different category of types of witnesses. This is not a witness with any personal knowledge, not like the officers you heard initially at the scene. This is a witness that's coming in to opine on an opinion. And the reason they were brought in to opine was during the Garrity statement process to offer opinions about administrative violations to SAPD during that investigation. That's why these individuals were brought in. That's why this training of sorts was called into question. And so we would say initially that purpose, that administrative finding, that Garrity issue, which has come up repeatedly in this court, is improper and impermissible to put before the jury. That is not the charged conduct in the indictment. That is not the standard in the indictment. We agree with Ben, we agree with Jason that that confuses and misleads the issues to an administrative standard. Next, Judge, moving to, well, does it fall under Mr. Lunan's argument of what's a reasonable and ordinary officer in the industry? What's that standard? And to that I would say the course was not TCOL certified. Ergo, it is not applicable and not given to the reasonable standard of officers across the state of Texas. It was an in-house training. I have the exact folks who did take it, most of them didn't, to include Chief McManus. But that's a rabbit trail, and I agree that that's a rabbit trail. The point is, if it goes to what's a reasonable officer's standard across the state, if that's going to go to the reasonableness of the decision, an in-house uncertified training that only some officers have taken that doesn't really apply to an IA administrative violation allegation definitely does not go in front of the jury. So, Judge, we would ask that under that theory, Sandoval, Hubert, and whoever else falls into that category, and I think it's pretty well laid out there in Ben's motion, those opinions with no personal knowledge they're coming in to opine on are inadmissible under 402 and 403 and are not proper to go in front of the jury. That's the argument we'd like to lay before the court.
And I have the,
Your Honor.
I have the slide if the court wants it.
Okay. Your Honor. Number one, I would go back and restate. Beyond the claim of policy, what was presented in the grand jury was Texas Code of Criminal Procedure 1404 and 1405 verbatim. And just for where 1404 giving an officer the right to arrest when a felony is committed, that statute has been interpreted under 5 of these states, 639, second 463, and it just lays out requirements. The person gives information to the peace officer has to be credible, the offense must be a felony, the offender must be about to escape, and there is no time to get a warrant. Those are the requirements established in case law by fraud. We also presented directly Article 1405 of the Code of Criminal Procedure, rights of an officer. In each case enumerated where arrest may be lawfully made without warrant, the officer or person making the arrest is justified in adopting all measures which you might adopt in cases of arrest under warrant, except an officer making an arrest without a warrant may not enter a residence to make the arrest unless the person who resides in the residence consents to entry or exigent circumstances require the officer making the arrest into the residence without the consent of the resident or without a warrant. I go back to 1405. That is the statutory law which this jury will have to apply from all of the facts. As to the notice of the experts and that class, they are giving their knowledge of what is trained to these officers. It may not have been everyone else they mentioned, but the training officers said these defendants had that information at the Rosemont Apartments June 23rd, 2023. It informs how they should handle it reasonably, and it also informs the jury as to what they knew as they assessed the information when they have to make the decision as to if their use of deadly force was reasonable. Also, since, again, the defense has continually cited 931 and 932 of the penal code as the basis that they're relying on, it is the state's position, under the facts which this jury has seen, that this has been an extended approach, that everything officers did caused a reaction, in effect, in lay terms, where not officers. I'm citing 9314. The use of force against another is not justified if the actor provokes the other's use or attempted use of unlawful force. The facts that have gone before this jury is that the deceased, Perez, entered her home at 0049. Officers intended to cajole, harass, etc., and then called it off. They retreated, got additional information, then go back and then resume the harassment that causes Ms. Perez, and the jury sees it. She reinforces the door with a chair. They observe it, they notice it, then they start to come in through the front. She reacts. They retreat, she backs off. It repeats again, they approach, she reacts, they back off. It is the state's position that reasonable minds can see that is a question and a fact for a juror to consider the 932 self-defense claim. All of this is based on statutory law, not policy, the law that this jury will have to apply.
None of that applies to the three gentlemen behind me, Judge. I don't know what this cajoling Mr. Harris is talking about. I thought we crossed this bridge already. No prosecutor that I've ever heard of in 23 years has used this against officers, so it's a misapplication, Judge. And everything that he just described to the court, with all due respect, applied to officers that are uncharged by this office. Charge them. Charge them with whatever you want to charge them with, but not these guys. These guys didn't do anything that this gentleman just said to this court, Judge. So it's irrelevant. There's not a nexus to that. First of all, it's a misapplication of that law. I think everyone watching, everyone, experts behind me, this honorable court, and all of us that prosecuted knows that that is a misapplication of the law, even if it applied to them, but it doesn't. Because what he described does not describe these gentlemen, their actions, Judge. So I don't know where he's going with this, Judge. Mr. Cifuentes was gracious enough to let me chime in because my ears were bothering me and my stomach was growling. So I'll let Mr. Cifuentes finish the argument, Judge, but none of what he said applies to the individuals behind me.
So,
Your Honor,
wait a minute. The argument that the state is advancing is disingenuous. Nowhere in the grand jury did they comply with Article 20A.258, which is how a suspect should be interrogated. They called some witnesses that refused to testify unless they were granted immunity, and they did not give the statutory warnings. If they knew that somehow or another the officers they called before grand jury had engaged in illegal conduct, and by some stretch of the imaginations, their conduct was sufficient under 6.04 to cause Ms. Perez to engage in illegal conduct to resist arrest, then the state should have given those witnesses who testified in the grand jury their statutory warnings under Article 20A.258B. They did not, and C, and they were required to give those warnings in writing. They did not give them verbally in the transcript. They didn't include an exhibit that they gave them the warning in writing. So their conduct before grand jury is inconsistent with what they're arguing now. If they're saying that it's relevant and admissible now, then they're confessing to having engaged in an intentional, willful violation of Article 20A.258 of the Code of Criminal Procedure. And this court would have a duty to had the state bar inquire into that unethical conduct. So either they engaged in unethical conduct before the grand jury, or they're making an invalid argument now. Either choice is untenable. And I should also say that their grand jury presentation talked about exigency as it's defined in the San Antonio General Manual, not as Judge Bimperod defined it. And these officers in a criminal setting are not constrained by the definition of exigency in the San Antonio General Manual. Their criminal liability should be judged by how a court interprets exigency, and they're opening the door to the introduction of Judge Bimperod's order and findings that there was exigency based upon my client saying, oh, and I'm not going to say the word, oh, whatever, we have to go in now when he learned of the existence of the invalid.
Judge, if I may, and hopefully put to bed, we went over again 1404 of the Code of Criminal Procedure and 1405. The policy cited in section 502 is verbatim, word for word, the statutory law. There is no distinction between the two. Counsel deftly skirts between its policy on one hand and then apply law on the other. They are verbatim, as is the preceding 14045, which is what has been continually stated that these officers could rely on. As to everything that has been stated has gone before this jury. This court will have to give an instruction that advises them on how to deal with the evidence that they've seen. I believe the phrase that we like to use here is the totality of the circumstances. That is before this jury. You can possibly narrow it out, but they've already seen it. And the law, our state law gives guidance on how to apply it. But as to it's relevant to inform the trier of fact of how to interpret the law they've got with the evidence they've already seen. And I believe that counsel's motion should be denied and that we proceed.
Your Honor, if I could just add one thing. He talks about the evidence before the jury. We are all governed by the rules of ethics and the rules of law in a courtroom. The fact that you were able to get before this jury evidence in your mind that the court, after hearing it, has already consistently ruled you cannot talk about an illegal arrest, and then the court went further and said you cannot talk about 9.41 or 9.42 because of your bizarre notion that all of these police officers committed a burglary of a habitation, including your first witness, I guess, Officer Rojas, who directed Salinas to go in through the window. And you did not read any rights to any of these officers before you lured them in and then dropped on them that, oh, by the way, you're guilty of burglary of a habitation. No one has ever heard such a bizarre prosecutorial theory in the history of this state. So what I would just remind the court is the court has already ruled they cannot get into the fact that this is supposedly an illegal arrest. They cannot get into that she was supposedly protecting her property and therefore allowed to use force, which 9.31 also says you can't even do that when it's arguably, this was a legal arrest, but even if you want to say it was an illegal arrest, she can't use force. And certainly under 9.42, she's not entitled to use deadly force. So once again, they're trying to, and finally, they're not going to get a charge from the court, I would respectfully put forth, about the San Antonio Police Manual. They're not going to get a charge from the court about some officer's non-criminal barricade presentation. They're not going to get a charge on that. So under the rules under 403, this is clearly prejudicial. It's clearly irrelevant. And they want to try to convict these men based on what is not even the law, what is not even going to go before the jury, and the court has already ruled what they're prevented from trying to put forward from the jury. Yes, the jury did hear your bizarre assertions about this case, unfortunately, but that's not the law that they're going to be charged with.
I would, for the record, object to the personalization of counsel's comments.
Yeah, I'll just instruct counsel to face the court when they make arguments.
Yes, sir. I apologize. Yes.
And I will speak to my shoulders abroad. I can take it. I will speak to again, as counsel seems to have a neck problem. We are citing the black letter law of the Texas Code of Criminal Procedure, sections 1404 and 1405. We are not citing to policy manual dictates, but I note for the record, the exhibit is in evidence, they are verbatim. Offered, thank you, sir. Offered by defense, and it is verbatim. The defense to date is said that they are relying on section 931 and 932 of the Code of Criminal Procedure. 931, subsection B4, brings up the factual reality of provoking the danger. The evidence, which is before the jury already, calls into question. We are simply arguing it and presenting it in line with our theory. As to any aspersions that I tricked officers who showed up and testified to their personal knowledge, everyone knew what I asked. They came in willingly. And so I would flat out object to counsel's citation to 20A. Again, I see no reason. This motion should be denied on its face. I yield to Mr. Loon.
Your Honor, in the proposed charge that you gave us days ago, okay, it contains in there, appropriately so, section 1405 that talks about giving this jury the opportunity to decide whether or not this arrest was illegal or illegal based on the fact that it was a warrantless entrance into a residence. That's in the charge. And it's fair for us to use things that in the charge that you've given us to be able to use that in front of the jury to suggest that the facts suggest that the entry into this habitation was illegal. So where does that go from there? We understand and we respect the court's decision that we cannot rely on 941 and 942. We're not going there. But we can go and argue that the officer's conduct was unreasonable in the fact that it was illegal. Okay? If the jury finds that their entry into that apartment was illegal based on 1405, which you have in the charge that you've given us in the charge, we should certainly be able to argue that the fact that they went in and if they believe that the entry was illegal, that goes to the reasonableness of their actions that night that resulted in the shooting and death of Melissa Perez. And if that entry turned out to be, and it's an entry by these guys, okay? If their attempted entry and their entry by these three guys ended up provoking Melissa Perez into coming at them with a hammer in her hand, the jury should be able to consider whether or not they provoked that difficulty by engaging in illegal conduct, which is left for the jury to decide about whether that exigency exists. You have in the proposed charge to us 1405, and you have in the proposed charge to us the definition of exigency. That's for the jury to decide.
Judge, I know you've listened to everybody.
I've given both sides an opportunity to make the argument.
You have, and I would just like to point out Because I think it's dangerous to talk about provoking the difficulty. As the court knows, provoking the difficulty is very, very specific. They would have to have some evidence in the record that they provoked the difficulty in order to have an excuse to shoot her. And that, I think, is a bridge too far. As far as 1405 goes, again, all I want to reiterate to the court is I believe that is a pure question of law that the court should decide. It should not be a question that goes to the jury because the jury doesn't have the ability to look at the case law and everything else like the court does to determine exigency and those things. At some point, we are still presenting evidence. I just wanted to make the court aware that we are going to ask the court, after the court's heard all the evidence, to actually make a legal determination on whether or not there was an exigency. And so I wanted to add that in.
All right, so a couple of things. First of all, the proposed charge that the court provided you on, that was really before the evidence began. That's definitely going to change, so I just instruct both sides to disregard that particular charge. I do want to caution both sides to stay confined to the law that is applicable in this particular case, to the facts of this particular case, and not go outside of that, because that could open up some doors that either of y'all would not be happy with. As it relates to this particular defense motion, I'm going to conduct a 403, and I have been conducting a 403 throughout the course of these arguments. The court will grant the defense objections related to any experts that will be offered to testify on officer policy. Anything else before we take lunch?
Your Honor, what about training? Are you, by your ruling, saying what these officers were trained about the appropriate way to handle a situation like this cannot be testified about?
Good. Currently, I'm going to sustain the defense objections.
Okay. As to training and policy?
Yes. All right, let's take a lunch, 12:30.
May be seated.
All right, members of the jury, welcome back. Hope you had a pleasant lunch. State, you can call your next witness.
Your Honor, the state calls Ms. Daisy Nieto to the stand.
Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may need to adjust the microphone, okay? Make sure everybody can hear you. It does move down. Can you introduce yourself to the jury and spell your name for the court reporter, please?
Yes, my name is Daisy Nieto. It's DAISYNIETO.
I'm going to give you a couple of instructions, okay? The lady in front of you is a court reporter. She's taking a record. Make sure the questions are asked in their entirety before you respond. She cannot get more than one voice at a time. Also, if at any time during the testimony an attorney stands up and objects, do not answer until I let you know whether or not you can answer, okay?
Understood.
All right. And all answers got to be verbal.
Understood.
State.
Good afternoon, Ms. Nieto. How are you today?
I'm doing well.
And are you a San Antonio native?
Yes, sir, I am.
What part of town?
I was born in San Antonio. I'm a San Antonio native. I was raised on the west side of San Antonio.
Okay. I'm not going to get into regional differences. And how do you know Melissa Perez?
Melissa Perez was my sister-in-law. She was with my brother. They entered into a relationship in 1998. That's when I met her. In 1999, she gave birth to my niece, Alexis. And shortly after, in 2000, her mom passed in a tragic car accident. And their relationship, the grief took a toll on her overall well-being, and so she and my brother separated, and so she remained as a part of our lives through Alexis. She was a connection to Alexis, and so she had 3 younger boys who we also considered part of our family because they were all a unit together, and so we treated them as such.
Okay. And so she stayed involved with your family in the years past?
Yes. Yes, sir, she did. She drifted in and out of our lives. My brother moved on and had his own relationships, and out of respect for each other, I believe they tried to set boundaries. But she was very close to my mom. When her mom passed, my mom became like her mom. My mom treated her as such. She drifted in and out of our lives. I often would visit unannounced sometimes because she felt that connection with my mom, and my mom welcomed her in that manner. It was home to her, I guess.
And you said that you've known her, Alexis was born in 99, so you've probably known her since 98?
Yes, since 98, yes.
Okay. Did it come a time that, not being specific, what do you do for a living?
Okay, I work at the VA healthcare system. I work with I work with men and women who have served our country. I provide behavioral health services to them.
Are you a counselor or therapist?
I'm a clinical therapist.
Did it come a time in your relationship with Ms. Perez that you began to notice changes in her mood, personality.
Yes, I did.
Can you pinpoint about when in that relationship you started to notice it?
I started noticing the changes in her personality, and I want to say it was like 2022. So I want to say February of 2022, but my actual like date of like seeing her in that, physically seeing her in that condition was in May of 2022.
Okay. And you say that condition, can you describe that condition?
She was having persecurity delusions, like she thought the FBI was going to, was infiltrating through outlets, through different things, and she thought that a lot of her delusions were centralized in her family's safety, specifically like her children, even us, like my mom, myself. My family and I had a horrific car accident in 2017, and part of her delusions were always trying to convince me that that something happened to us because these entities were trying to get to her, but through us, if that makes any sense.
You said about 2022 is when it confirmed your concerns got, I guess, hardened or formed.
Yes, sir.
Did you and your family, and by family, how many siblings do you have?
I have an older brother and a younger sister.
What type, did your family try to take any steps to help support her? And were you concerned about your niece Alexis? And what's her youngest son's name?
Her youngest son's name is Dylan.
And the other two?
It's Aiden and Jaden.
Did your family take any steps to try to help support your niece and nephew, your niece's mother?
Yes, we did. And like I mentioned, in May 29th of, I want to say it's May 29th of 2022, was my first time physically seeing her in that condition. And that was something that I was not accustomed to seeing her. When I would see her, she was not in that mental health state. And so when I discovered that she was in that situation, I did what I would have done for anyone, is call to get her the assistance. My goal was to get her ED that day, and thankfully she was. And that was the biggest breakthrough, because that allowed the opportunity for her to go into rehab and to find some hope through this whole situation that she was in.
May I approach the witness, Sharon?
Yes.
All right. Sorry.
And so you said May 29th of 2022?
Yes, sir. And so she was admitted, I believe she was admitted at Methodist Transplant Center. And typically the turnaround time for an admission is like 4 to 7 days. So I knew I was working with like very little time. And so it was very difficult to gather information when I would call, unless she would put me on her list to be part of that process, or to have consent to talk to her or talk to anyone. And she did. And I was able to talk to the clinical team. Their discharge time was accurate. It was a couple of days, and they were going to discharge her. I asked them if they could please give me additional days so that I could start the process to get her into a rehab center. I did run into a lot of barriers because she had a particular insurance plan that didn't cover a lot of these places. That specific day, the clinician there at that hospital said, "I have these 3 leads if you want them." And I took them. And those 3 leads led to 9 leads in all. And so some didn't accept her insurance. Some were self-pay, so it was $20,000, which we didn't have. And neither did she. And by the 9th one, thankfully, she was able to, that particular site, which is Starlight Recovery, took her. They said that they could admit her. But it was a quick turnaround time. Like they gave me a list of items that she needed to take with her. And so as a family, we provided always to like help her with like specifically with these transitions, getting her like a huge duffel bag, hygiene products, whatever was on that list, we provided because we wanted her to have that opportunity to get better. And so those items were dropped off. The Starlight Recovery staff picked her up from Methodist Transplant Center, and she got admitted, or she entered rehab during that time. Sorry. And so that was provided for her, like items. Even while she was there, if she needed something, they had like like an aquatic meditation class or like just different activities for them. We provided those items.
And how long was she at Starlight Recovery in Kirby?
I believe she was there a month. I was hoping she would stay longer, but her insurance only covered about a month.
Okay. And when this whole started with US, what did you literally do to start the ED at Methodist and then this Start Recovery? Who did you call?
I called SAPD.
Okay. You called 911?
Yes, sir.
Now approach the witness, Sherman.
Yes.
Ma'am, I'm showing you what has been marked as State's Exhibit number 190 for identification. Do you recognize, is that your name on 190?
Yes, sir.
Take a moment to flip through the attachment and the underlying offense report. Okay.
Yes.
The underlying offense report from State's Exhibit 190 for identification, does that fairly accurately reflect what you recall telling SAPD about the state of your sister-in-law, Melissa Perez?
Yes, sir.
And I'm showing you what's been marked as State's 191 for identification. What is 191 for identification?
It's a letter from the Starlight Recovery Center.
And is that letter, is that the recovery center you got her into after the ED from May 29th that's in 190?
Yes, sir.
And this is the facility you coordinated with, and it references her treatment?
Yes, sir.
You will just leave those there to refresh your memory and recollection. We'll continue. So, how long was the ED at Methodist Specialty and Transplant from May 29th of 2022? How long was she there in the hospital?
I believe she was there for a couple of days, or maybe more than 4 days. I'm not sure, sir.
Did you interact with and talk to any of her treatment providers there in the hospital?
I talked to a clinician that was in charge of the discharge planning.
And did they give you guidance about what she would need for a follow-on care?
They, because she was being discharged to the Starlight Recovery Center, their discharge plan was her discharge plan was the Starlight Recovery as an option.
Okay. And I understand your testimony, she was there for about 30 days from July of 12th of 2022.
Yes, sir.
And when she got out of the Kerrville facility, what happened? Did you all just send her on her own or what?
So when she was, again, it was like a healthcare barrier, like the insurance would not cover additional days. And I had spoken with her like substance use counselor or to ask if she had any recommendations for her, and they recommended the Oxford home. It's a home here locally in San Antonio. It's composed of other individuals that are struggling or have struggled or are in their recovery stage of they're just a recovery stage, and so she had to apply for that placement. They go through a rigorous application process where they have a phone call meeting with all the residents in that home. The Oxford home is a home that's donated to the community by donors themselves who have experienced either a family member going through similar situations that we experienced with her. And so they had rules there, and they had the residents had to agree that she was a good candidate to live and reside there. And so the goal was for her to stay there as she transitioned, so that she can continue her classes, like her AA classes, her NA classes.
Now, you mentioned NA, is that narcotics anonymous?
Yes, sir.
The diagnosis, what was it? Was it just substance abuse, or did she have something else?
We were told it was schizophrenia.
Did the family continually try to stay involved with her to support her?
Yes. So at the Oxford home, she could get. She was allowed visitors. It's designed for for children to also be there. They have like a swimming pool space. They have board games. Like it accommodates children as well, and they could spend the night there as well with them. And so the children would go see her there. We would see her there. We drop off items. She got employed right away. So there was a lot of. She had an interview at a local like office space, like cleaning offices, because that's part of the Oxford home requirements. She had to pay rent there, and so that was part of that responsibility. Was she had to provide her own hygiene products, but also pay a portion of like the bills that were assigned to every resident there. And so she did not waste any time. She found a job. She would walk to her job. So the Oxford home is located on Bandera by the San Antonio Aquarium, and she walked all the way to 410 by I guess like the Marshalls area, like that little Ingram shopping center. So she would walk over there. It was a nighttime job, so I would Uber her back home at times because I didn't want her walking. She was very considerate. Like she would always say, "Don't spend your money. I'm fine. I can walk." But I chose to Uber her when I could, or when she asked if she was tired.
Okay. Now, let's be honest. But she also, were there other times you got concerned about her, you had to call the police again and try to get her ED? Were there other occasions?
Yes, sir. Each time I called SAPD, it was with the goal of getting her ED.
About how many approach her?
Yes.
Showing you what is marked as State's Exhibit number 192 for identification. 192 for identification. Is this the same type of, it's marked an incident detail report. Does this look like the same document from 190? The call you made that resulted in an ED to Methodist Specialty? Does this look like the same thing?
Yes.
And is that you as the caller?
Yes, sir.
Okay, and if you take a moment, flip through 192 for identification. What day did you make this call?
The incident date is May 26, 2023.
Okay. Do you remember what caused you to call SAPD to try to get an ED on May 26 and 23?
On this occasion, she showed up to my mom's house, and and my mom called me. I believe my mom called me in this instance and mentioned that she had arrived and she didn't look like she was doing okay. And so I called on this day to SAPD for a welfare check.
Did she hurt your mother?
No, she never hurt my mother. She never hurt any of
Your mother was just
us.
concerned about her.
I'm sorry?
Your mother was just concerned about her.
Yes, my mom was just concerned because she wasn't accustomed to seeing Melissa in that condition. That was something new to her.
Are you aware that she had had previous arrests in the past?
The USB drive that was provided to me shed light in a lot of the things that I did not know.
Okay. So those are things you did not know?
Correct.
I want to talk, did you help her get housing?
Yes, I did.
And did you help her with getting housing at the Rosemont Mills Apartments at 6200 Old Pearsall Road?
Yes, sir.
Okay. When did you help her move in there?
I believe it was in September that she didn't have any, it was a bare apartment, so we helped her to move in. We helped her the goal was for her children to have their own space, so we got the apartment furnished for her. It wasn't new stuff, but it was like hand-me-downs, and she was very appreciative of anything we gave her. So that was about September, sir, sorry.
So that would be September of 2022?
Yes, sir.
Okay. Did Dylan live there with her?
Yes, he did.
Okay. So it was just her, and about how old was Dylan at the time?
I believe Dylan was about 9.
Okay. And Alexis, she was grown by that time?
Yes.
And the other two boys, where were they living? Aiden and Jaden, where were they living?
Aiden and Jaden were living with their biological father, Mr. Reyes.
If you're aware, would Aiden and Jaden sometime come and visit their mom and their younger brother
Yes.
at the old Pearsall Apartments?
Yes.
Do you know what type of sleeping arrangements did she have for when Aiden and Jaden would come?
Sleeping arrangements, like for them to, can you rephrase that?
What type of beds did they have?
They had, I believe, so she had her own bedroom, and then Dylan had his own bed as well. So I'm not sure on the sleeping arrangements, but I know that there was like space for them to sleep in.
Okay. Was there a time towards the end of December of 2022 that the family got concerned about her again?
Can you repeat that?
Was there a time towards the end of 2022? Well, let me rephrase. So when she moved into Rosemont Mills Apartments, Dylan moved in with her.
That is correct.
Did he stay with her? Did he ever have to leave?
He stayed with her,
Okay.
and then he had to leave.
About when did he have to leave?
He had to leave in December of 2022.
Do you have any personal knowledge of what caused that?
So in December, there was a social worker that was assigned to a school in the district that Dylan attended, and that social worker made a home visit. And when they approached the home, because Dylan hadn't been at school, they noticed that Melissa was not herself, like was not acting like herself. They mentioned they had been there before, I believe, and they just said that she was talking about like children being in danger, and that's why she hadn't sent Dylan to school.
After this incident in December of 22, did Dylan have to go live somewhere else?
Yes, she voluntarily signed a parental child safety plan. It's a plan that CPS gives individuals that, it's a temporary plan, so the parent will voluntarily sign this plan. And the goal of that safety plan is to return the children back to a safe environment. But in the meantime, the parent that signs this gives authorization for them to stay at a relative's home or whomever they feel that the child will be okay with.
What relative was Dylan placed with?
He was placed with my niece, Alexis.
And did you also interact with Ms. Perez over this time frame?
During the time that after 2020, after Dylan left?
Yes, ma'am.
Yes, I did.
So did she do that willingly?
To interact with me or to?
No. Did she willingly give up her son Dylan to live with her daughter?
Yes, she did.
Did she recognize she wasn't well?
She did.
during the turning into calendar year 2023, did you all visit her or check in on her at the at apartment 3102 at Rosemont at the Mills Apartments?
Yes, I did. I provided, like I mentioned, if she would call me and ask for something, I provided hygiene products, whatever she asked me, I would tell her, like, you have to give me some time, like I can't just drop everything I'm doing, but I will be there, and she understood. I would provide food, like I would Uber her food. She started a job at Bill Miller's, like literally like adjacent from the apartment complex, so she needed like work boots, and in her own like humble way she would call and ask, like, can you please get me some working boots and I'll pay you when I get paid. And so she says, I'll walk to Walmart. The Walmart was on the other side of town, so I would tell her, I'll Uber you there, I'll pay the boots. And I provided as much as I could during that time. I also had my family. I have beautiful children that need my attention as well. So I did the best I could when I had that opportunity. And so in January, I would drop off medications too, pick up medications for her, and drop off medications. And I would definitely stress the importance of taking those medications all the time.
To your knowledge, well, if you don't know, don't answer. Did she also work as a roofer?
She did.
How did you come to learn, how did you find out about your ex-sister-in-law's death? How did you find out?
It's not abnormal for me to check the news in the morning. I think we all do that. And I checked the news, and I saw the headline. I don't remember what the headline said, but I saw the apartment complex, and I knew that side of the apartment complex is where she resided. And so I called SAPD. I called 911 to ask if she was the person that was involved in that situation.
And was it her?
Yes.
And did you and the family later on that day, did you meet with SAPD that day on the 23rd?
Yes, the officers, the detectives, they reached out to my niece. they reached out to my niece. They asked us to go to headquarters. So my husband and I and Alexis and her husband traveled to the headquarters. And prior to that, the detectives went to my mother's home because that's where we met. And that's where we were introduced to both detectives. I believe Detective Soto is one of them. They were very empathetic through that whole process, and they delivered the news. They didn't give us details, so we didn't know anything about what was going on. That's why we were asked to go to the headquarters, because they were going to show like the actual footage or give us more details.
Approach the witness, Sean.
Yes.
Ma'am, I'm showing you what has already been admitted into evidence as State's Exhibit number 158. Do you recognize the person that's in State's 158?
Yes.
And is that Melissa Perez, your sister-in-law?
Yes.
Take a moment if you need.
I'm good.
Okay. I'm also showing you what has been introduced into evidence as State's Exhibit number 63. Correction, Defense Exhibit 63. Who's that person?
That's Melissa.
Is that the way you'd rather think about her?
Absolutely.
Ma'am, aside from meeting with our office to prepare for testimony today, did you ever give a statement to law enforcement or anything?
Aside from,
Just talking to, did you give a formal statement to police or law enforcement?
no.
And you said you've testified you did call 911 the morning of June 23rd, 2023.
The morning of June or May?
June 23rd.
Oh, yes, sir, I did.
Ma'am, I have no further questions for you. I will pass the witness. These gentlemen may have some other questions. If you'd be as helpful to them as you were to me, I appreciate it.
Yes, sir.
May I proceed, Judge?
Yes.
Ms. Nieto, my name is Jason Goss. I represent the officers here. I do have a few questions for you. First, I'll say, I can tell, I know it's hard. I'm sorry. I'm sorry that you have to be here. I think everybody's sorry that we're in this situation. It sounds like you're a very good sister-in-law to her, and she was blessed to have you. I do kind of want to talk about the relationship. One of the things that Mr. Harris left off with, he said, he asked you if she was a roofer. And just so that we can be clear, like, what that means, what you understood is that she spent some part of her life working in construction, right?
That is correct.
And specifically, she would be like the people putting together roofs of houses.
Yes.
Right. And she would use a hammer for that.
Yes, sir.
And she was strong.
I assume for someone that works on roofs, you have to be, right?
I would agree. Yeah, I mean, because, you know, it would be hard for me to do, and that would probably be for you to do as well. That's not really what we're trained to do, but,
Well, not females, right?
well, yeah, you know, I mean, but she was a female, and she was able to, you know, work construction and build roofs, and that's something you knew about her, right?
Yes.
Okay. So, you know, we talked about her children, and you talked about Alexis. Alexis is her oldest daughter, is that right?
That's correct.
And only daughter.
That is true.
And so, and Alexis she is your blood niece,
Yes, sir, she
blood
is.
related, your brother's daughter.
Yes.
Who raised Alexis?
Alexis was raised, my brother was very young when he became a parent, a father. So my mom helped a lot, helped both of them, but she lived with Melissa at times, and at times she lived with my mom. It just depended on the work schedule. My brother, he had a very distinct schedule. His schedule is like 2 weeks on night shift, 2 weeks on day shift, and so that interfered a lot with picking up, dropping off, things like that, like the normal routine.
And you said Alexis was born in 1999?
That is correct, sir.
And how old was your brother when she was born?
I believe he was 18, sir. He was young.
And then later on, I guess with, you said Melissa and your brother broke up and Melissa had other children.
Yes, sir.
And that's Aiden, Jaden, and the youngest boy is
Dylan.
Dylan. So, as far as Aiden and Jaden, who raised them?
Melissa primarily raised those children.
Was there ever a time that they were taken away from her or that CPS removed them?
They were never taken away, sir. She voluntarily signed that document that I mentioned earlier.
And I think, and just maybe correct me if I'm wrong, I think when you were talking about that document, you were talking about Dylan. Did she also do that with Aiden and Jaden?
I believe so, sir.
Was that before she did that with Dylan?
I don't remember that part.
Okay. How old is Aiden and Jaden?
Aiden is 17 and Jaden is 14,
Okay.
I believe.
And so 2 years ago, been 15 and 12.
Correct.
And then you said Dylan was about 9
Yes, sir.
back then.
Yes.
So at the time that she's getting ED'd and those things, did she have custody of Aiden and Jaden?
Yes, sir.
Okay, she did have custody of those two.
Yes.
At the,
Which ED?
well, the first one that you knew about.
Okay, the first ED, which is what day, sir?
I think the one you said the first time you knew, you said you had heard something going on in February, but the first time you had like actual visual understanding of what was going on was in May of 2020.
Yes, sir. In May of 2022, she did not have the children then.
Okay. And you said you said you guys, your family was in a pretty bad car accident in 2017?
Yes, sir.
And from looking at it, it looks like her criminal history goes back to about 2017. You told the prosecutor that you had reviewed like a USB drive?
Yes, sir, I did.
Can you tell us what was on there?
The USB drive just had her her history with Child Protective Services. It's like the open and closed cases of CPS records.
And so those CPS records, that was the prosecutor that gave you that drive to review?
Yes, sir.
In order to prepare you, because I guess you were told that we would probably have questions about her history and her issues with CPS and her issues with the law and everything else.
They asked me to familiarize myself with those documents.
Sure.
So that I can just know there's so many dates involved with all this process. So even asking about the ED situations, like I have to reference back those dates, but.
Sure. No, and I'll tell you this, just so you know, I am not going to try to trip you up on dates or anything like that. I know witnesses get afraid sometimes, we'll work it, we'll figure it out.
I appreciate that, sir.
Yeah, no, so that's not my purpose here, but Judge, may I just stand up for a second? So that drive that you were given, now this is a paper copy, but the drive that you were given, it had a lot of pages in it that you reviewed.
It had not that many pages, but it had some pages.
Okay, and I mean, and that was the CPS history, and was it just CPS, or did it have other law enforcement stuff, or was the law enforcement stuff put into the CPS history?
It was combined, sir.
Yeah, because a lot of times with CPS, what they'll do is they'll say, well, here's the CPS issue, but also she's been arrested for assault, or, talk about her legal issues as well, right?
If that's how they do that, I wouldn't know, but I mean, that's what I saw.
Yeah, and I guess that's what I meant. From what you saw and what you were familiarizing yourself with, it was kind of her whole history with CPS, including kind of some of the law enforcement and some other criminal issues that she had.
I did see that, but I also saw that there's like redundant pages of the same, like, I guess just their policies. So I saw a lot of those pages, like a repeat in each of the cases of like resources that they offer. So like, I think it was like 7 pages of like just resources, the policies, the procedures that they follow. So I did notice that as well.
And did you see, were you able to see, because different CPS matters over the years would deal with different children. Like for instance, some children weren't born yet, some children were born later, some children were already grown. And did you see who the CPS records dealt with specifically as far as her children? Like, who was CPS trying to protect? Was it Aiden, Jaden?
Like
Was it Alexis?
a specific child, or
Right.
I believe when you make a report to CPS, they investigate the entire unit, not just one.
Sure. But you would know that, I guess, or you would have seen that there were some specific concerns about specific children. For instance, Dylan, when Dylan was taken away, or when she voluntarily gave Dylan to Alexis in December of 2022.
Correct.
And that would have been specific to Dylan because Aiden and Jaden weren't there.
That is true, sir.
Did you see any that were specific to Aiden and Jaden?
In the past, yes.
Yes, in the past. Okay, so, I kind of want to talk about that with Dylan, because since you had seen that, what you told the prosecutor is, and which is true, the counselor had concerns that she wasn't acting, that Melissa wasn't acting normally, that she was acting strangely, right?
Yes.
And Dylan was a little boy, he was 9, and he was there at the house with her, and there was a concern for his safety.
Yes.
Yes. And one of the reasons there was a concern is because Melissa had told Dylan that she would kill him if he didn't get out of the house.
I didn't read that on there, sir. Can you?
You didn't see that in the CPS,
I didn't see that specific.
Did you know that she had those delusions that people were trying to hurt her, trying to hurt Dylan?
Yes, I did know that.
And that she had told Dylan that people in the vents and the roof were trying to kill him? Did you know that?
I did not know that.
Did you know that she had a delusion that somebody was living inside of Dylan's ear and was molesting him and assaulting him?
I knew that through the records that I familiarized myself with.
Right.
Yes, sir.
Right. And so, and you would agree, I mean, you work, and thank you for your work with veterans. Officer Villalobos was a Marine, and I know that he appreciates that too. I'm not saying you're an expert at these things, but you can just tell based on your knowledge and your work that these are some pretty significant delusions and hallucinations.
It's a serious mental illness.
And potentially dangerous if those delusions and hallucinations are acted upon.
Potentially, yes.
Right, because I think one of the things on the ED specifically, the one we were talking about from May of 2022, and you can refer to what you have up there. I think you have the offense report as well. But you were actually the reporting person. I see your name, Daisy Nieto, on there as R1. Judge, can I come real quick?
Yes.
I don't want to.
This one?
So R1 is like reporting party one, or, on mine, it's actually got you labeled as the R1. But, at that time in May of 2022, one of the things that you're trying to explain, because you said your goal every time was to try to do an emergency detention, right?
That is correct, yes, sir.
Because of her mental health concerns, that's what you felt that she needed.
At the time, yes.
Right. And, but one of the things you said to the police at the time when talking about that is, and it's kind of a few sentences down, R1, that'd be you, informed me that when SB1, which is Melissa, gets these episodes, she attacks people for no reason. And you said that.
Yes, but can I clarify on that?
Well, let's sit there at first.
Okay.
So you told police that when she gets in these episodes, she attacks people for no reason.
It was collateral information that I had received earlier in the day when I called for an ED. So this was my second time calling SAPD that day. During the first visit, an SAPD officer went out to a different residence, asked her the questions that they normally ask to determine if she meets the criteria for an ED. And at that time, sir, the officer did not ED her. He asked crucial questions. When I said in that statement, when I said she gets episodes, she attacks people for no reason, the officer that showed up that day in the midday, he asked all the right questions because she had disorganized thinking, and so she was not. He would ask her a question and then she would answer a different way. And so he asked very crucial questions, and a lot of this that I wrote down is what he obtained. So following that sentence, that she attacks people for no reason, R1, which is me, informed me that SB1 had several injuries to her face. The officer that showed up to respond, when I physically saw her that day, that was my first time seeing her. She had huge bruises under her eyes. They were in healing stages. And she informed the officer, because he asked her, how did she get those bruises? And she said that she was looking for her children, and that she had fought someone on the bus because she believed that these people had taken her kids.
Right. And so if we could talk about that a little bit. That I know when you were saying she attacks people for no reason, she has a reason. Right, but that's not necessarily. It's not a good reason. It's a delusion. It's a hallucination. It's a delusionary reason. A delusional reason that she.
It's not reality, but yeah, that's her delusion.
Right. Her reason is so she attacked a random stranger on the bus enough to where they had to fight back and injure her, and the reason being is she felt this random stranger had taken her children. Right.
That's what she told the officer.
Right, but you can see that. From the random stranger's point of view, that's a pretty bad deal to go through, right?
It is a bad thing to go through, yes.
Sure. I mean, and so because of her mental health condition, it didn't make the situation any different from the guy who's fighting this woman off, who's attacking him for no good reason, right?
I wasn't sure if it was a male or female. All I gathered was this, sir. It was collateral information I was relaying to the next officer.
Yeah, it does say person, so you're right. So either this man or this woman who is being attacked by Melissa and fighting back against Melissa's attack, right? That you would agree that that's an act of violence committed by Melissa, right?
That is, but I'm not sure if that in itself, sir, like, again, Melissa would say a lot of things, so I don't know how accurate this stuff is.
Assuming that it is, because she does have injuries like she was fighting with somebody.
Yes, sir, she did.
Right, so assuming that it is, you would agree that that's an act of violence perpetrated by her, right?
If anyone engages in in a fight, it's an act, if it's mutual, yeah, it's an act of violence.
Well, sure, because obviously the stranger on the bus who never took her children wasn't trying to get in a fight that day, you would assume.
I would assume, yes, sir.
It was Melissa, through her delusion, that started to fight this stranger
Yes, sir.
and got fought back in return.
If that is true, sir,
Sure.
what she said was, if this is accurate, then yes, sir.
And I guess what I'll say is if she had said that and didn't have any injuries, then we might go, well, maybe it happened, maybe it didn't. But she said that, and what you said was she has huge bruises on her face.
She had huge bruises in healing stages.
And that, so the person that fought back, based on it's in this report, she attacked a random stranger on the bus. The person that fought back against a woman suffering from schizophrenia in self-defense. Right?
I wasn't there, sir.
Right,
So
but
I'm
just
not
based
sure.
on what you can read here as part of the ED that you tried to get her ED. Based on that scenario that we have in this report, this person fought back against Melissa while she was in a schizophrenic episode and injured Melissa, hurt her. And the person fought back in self-defense, right?
If that's what happened, yes, that's what happened.
Right, because if Melissa was correct and this stranger really did kidnap her children, she would have a reason to attack them. Right?
Correct, but she wasn't stable.
Yeah, and she wasn't correct.
No,
So-
she wasn't.
Right, so the person turned out just to be a person unfortunate enough to come across her when she was in that stage, or not being stable. You would agree with that?
If it's true, yes.
Right. And so and talking about that phone call, and I guess just to kind of put a cap on that, you would agree with me that Melissa, when she was in these stages, was capable, assuming this is true, was capable of unpredictable violence against other people.
Are you asking if she was, or if like someone that's experiencing schizophrenia is? I'm not
I'm
sure.
asking her specifically.
Okay.
Taking this as true, what we've been talking about. She believes random stranger has kidnapped her children, she physically attacks them, assaults them, gets assaulted in return, right? You would agree that, assuming this is true, which is, it's in the report, and she had injuries, that Melissa is capable of unpredictable acts of violence against others.
I'm not sure how to answer that, sir. Can you rephrase it? Because I'm
Sure.
trying to answer in the right manner.
No, I understand. I know you're doing your best. So, we'll put it this way. There's no way a person can know that what's going on in her head is that she thinks that I've kidnapped her children, right?
Right.
Okay. So when the attack comes, that's unpredictable. You would agree with that?
That is true.
And so assuming all this is true, is Melissa has unpredictably attacked a stranger for something that's going on in her head, right?
Right.
Right. And so when Melissa is in that stage, strangers and other people are at risk of being attacked violently. You would agree with that?
Yes, sir.
Okay. So and I just kind of want to move to your mother, and I can already tell your family's important to you. Your mother is, your children are, just like mine are. So I'm not talking about your mom in this situation in a way to hurt you or embarrass you.
Okay.
But you did bring it up as far as the 911. And so one of the things, because we had that 911 call, so you told the jury that, you told her that Melissa had been over at your mother. Do you remember about when that was going on?
She showed up periodically, but it was February, I think, the first time.
When you called 911?
Yes.
Okay. And I guess just as a background, how many times in your life do you think you called 911?
For other reasons?
Yeah, I mean, just in general. Would it be less than 10?
In my profession, I've called more than 10.
Okay. I guess personally.
Personally,
Yeah.
I don't know, maybe like these instances.
Yeah.
Probably like 5 times, I don't know.
Sure. And how old are you?
I'm 41.
Yes, I'm sorry to ask your age, but, and how old's your mother? Roundabout.
65.
So your mother's 65, and the point I'm making with that is when you call 911, if in all your 41 years you called it personally 5 times, mostly to do with this, it's kind of a big deal to call 911, right?
Right.
You're doing it because you're showing you have a concern.
Right.
And so when you called 911 on this occasion, it was because you had said that Melissa had shown up at your mother's house. She was acting strangely. It scared your mom.
It concerned my mom.
It concerned her. And your mother called you. And so your mother called you, and then you called 911 to go out to your mother's house.
Yes, sir.
Right. And one of the things you said is you said, I'm very concerned about her, meaning Melissa. I don't think she's in the right state of mind. And I worry about my mom too, to be honest. Do you remember saying that?
I was worried for my mom because she had never seen Melissa in that condition, and she loved Melissa, and so that was new to my mom. My mom wasn't a professional. My mom wasn't a police officer. My mom couldn't de-escalate her. My mom could talk to her, try her best to redirect her, but in my family, we had never dealt with psychosis or any form of schizophrenia like that. That was completely new to us and to my mom. And so, yes, sir, I was concerned for her.
Right, and you know, and I think that I'm not questioning your concern for her, because I would be concerned for my mother, and I think anybody would be concerned if she's in a decompensated state, and you don't know, and she's unpredictable, and you don't know what's going to happen, right? And so you are, when you're talking to 911, she's in a house, your mother's house, with your mother, and one of the things you wanted to make sure that they understood was that you had concerns for your mother's well-being, right?
Yes.
Okay. So you also said when you were asking for them, like whether or not, I think you had said specifically you were asking for her to go to, or you said she had been at the transplant, the Methodist Transplant Center, I guess the specialty hospital. And then you said, you know, I don't know, like physically, like taking her, she's going to fight us. It's going to be very aggressive, but she is not doing well at all. Do you remember saying something like that?
Yes, I did say that. So when you're calling in the heat of the moment, like to dispatch or to SAPD, personally, this is me speaking, like I've called multiple times, and it's crucial that you just deliver what you have to deliver. And at times, like for instance, in that time when I said she'll fight us, I meant like she was not going to agree, like to let us take her to a hospital, because she didn't even recognize that she had an issue, right? And so Melissa never harmed us. She never hit me. She never harmed my mom, my dad, my brother, who was in a relationship with her. So when I said she'll fight us on it, I meant she would not be receptive to going to a hospital.
Sure, but you also said it's going to be very aggressive. I mean, aggressive is a little bit different than just, you know, she's going to be angry. You know, the aggressive part it suggests something more physical, or something, at least if you are talking about verbal, something very, very upset, very angry, right?
Verbal, maybe, yeah.
Okay. So, I mean, you said that, oh, it was, you know, she didn't hurt us, she didn't touch us, but you do know that she had threatened random people with a baseball bat.
No, I did not know that.
Yeah, so you didn't know that. That she has, you know, one of the things you said is that in this kind of situation, you wanted to make sure you were giving the police the information that they needed to deal with her, right?
The information they needed so that she can meet the criteria for an emergency detention.
Sure. And because you know that that's important for them when they're responding, to understand what they're responding.
Yes.
Right. Did they ever, or the police, when you talked to Detective Soto and Dorsey, did they ever tell you that, that when these officers responded, that nobody had said anything to them about any kind of mental health problem that Melissa had? Did you know that?
No, sir, I did not know that.
Right. Because in what we found out and what we've kind of done through the trial is we've understood that the first officer on scene did recognize that she probably was going through something, but he never updated it so that everybody else would know. So nobody came out there knowing that she was in a mental health issue at all, but you didn't know that.
I did not know that, sir.
And by the time that they got out there, nobody ever told them when they were out there that there was any mental health issues or any problems like that, and you didn't know that either?
No.
Okay. Because, it's been characterized as like they responded to a mental health call, but the call was for she had committed a crime. And so they were responding because these guys were responding because she had thrown a candle and hit an officer in the arm. Did you know that? What you saw?
When I met, after, like when we started meeting with the DA, we learned details. But Officer Soto and Detective Soto and the other detective, they did not we weren't privy to that information because we weren't blood related. So
Right.
I didn't get that information from them, and I'm not sure if my niece did either.
Yeah, and I mean, and I guess additionally to the candle thing, she had also taken that hammer and come out of the window and tried to hit one of the officers in the head with it. Did they show you that on the body cam when they brought you in?
No, sir.
Okay, because I know that they did, I was going to talk to you a little bit about that, that they did bring you in, I think you mentioned it, they brought you in, they kind of talked to you. But first, in your knowledge of Melissa and some of the things she was going through, she was a methamphetamine user, and you know that.
That's correct.
Right. And you understand as a healthcare provider that methamphetamine use makes schizophrenia much, much worse.
It exacerbates its symptoms, yes.
Yes. And so, and we all understand about self-medication and those types of things, but that is a choice that Melissa made to use methamphetamine. You would agree with that?
Sir, it is a choice, sir, yes.
Because everybody who has schizophrenia does not use methamphetamine. That's not a symptom of schizophrenia. It may be common, but it's not a symptom.
Can you rephrase that? Because I'm trying to follow you.
Sure. Dealing with people who have schizophrenia, and I don't know how much you've had in your professional life, because I'm sure that a lot of the veterans that you treat are not schizophrenic, I would say.
Sir, there are some veterans that do,
Sure.
and we have a specialty clinic just for them.
Okay, so, and I guess what I'm saying is that somebody who has schizophrenia, that having schizophrenia doesn't require, the disease doesn't make them use methamphetamine. You would agree with that?
Yes, sir.
Right. It's a choice that somebody with schizophrenia may make, right?
A choice to self-medicate, yes.
Sure, self-medication. Now, she actually had actual medication.
Yes,
Right.
she did.
And when she was on the medication, she did better.
She did better, however, they had side effects, and so she would always tell me that it would make her sleepy. It's not uncommon for them to discontinue their medications once they start feeling better, and I think on some occasions she felt like I'm better, I think I'm okay. And then there's times where she struggled with the fact that the medications had those side effects that would make her feel like sleepy or zombified, like just not herself.
Sure, and do not get me wrong, I understand. I know that it's common that people feel that way. And I know that it's common for when people who have schizophrenia, when they start feeling better, they discontinue their medication. However, the choice to discontinue the medication and not go through the side effects and stay mentally healthy, that was her choice to discontinue the medication. You agree?
I think it was her choice to discontinue, but I also feel that there was not a lot of understanding as to why it was important to stay on her meds, or what this particular serious mental illness, what it entailed, right? And the importance of being medicated and how that would help her. Because there's a lot of individuals who are experiencing or living with schizophrenia, and they're productive, they have, they go to work, they go to school, and so they're high functioning. They're experiencing schizophrenia or living with schizophrenia. The psychiatrist that we hired for her, because my mom and her stood in line 3 days in a row at the Center for Healthcare Services. That particular, after the third day that she wasn't going to be seen for those intakes, she kept going back. We decided as a family to hire a psychiatrist to help her, and that psychiatrist did an amazing job trying to explain to her what a delusion was. And don't get me wrong, she was fixated on the fact that she had these like involuntary tics, or she she was trying to understand it as best as she could. But that psychiatrist really focused on her strengths, and one of her strengths was that he told her that she was making so much progress than what he typically encounters. And so what he was saying was, you have a job, Melissa. You're in orientation. You're doing these things that typically I don't see at this phase of treatment. And so I was very thankful for him, because he took his time to explain it to her. It's different. Like, she wasn't my client, my patient. So I explained as I could, but I couldn't cross that boundary. She was a loved one, and so I never intended to treat her or provide like therapeutic interventions. I just simply helped her.
And I appreciate that you did. I will say that not many people, with her means, with her insurance situation, like you talked about, it sounds like it was difficult standing online, like waiting in line for 3 days trying to find healthcare, which is, I think, a problem with the system that we have. But not many people in her position are lucky enough to have somebody like you and your family hire a private psychiatrist to sit down with her, which is what you did for her, right?
Yes, sir.
Okay. And the psychiatrist focused on her strengths and explained the importance of the medication, explained what delusions are, tried to go through the delusions, tried to break some of her delusions, right? That's what the psychiatrist was trying to do.
Yes, sir.
And even despite that, she made the decision not to take her medication. You agree with that?
She made that decision. She
Right.
was in our clinical field, we call that self-determination of the client. Like, you can't force them to do something.
That's right. And in making that decision, as well as using alcohol or methamphetamine or any of those other things, that exacerbated her schizophrenia, right?
Yes, sir.
And we know that the way that her disease, because everybody with schizophrenia doesn't act or react violently. We know that.
A vast majority do not.
Vast majority do not, but she is somebody who did. You would agree with that?
She's someone that was not on her medications, and when she wasn't,
She would act violently,
she would not act herself.
which, and I know it's hard, but and not herself being violent. She would be violent.
Based on what I never physically saw her be violent, sir, but based on what I'm reading, yes.
Yes.
And that's what it says on there.
And, when I guess, your brother's Antonio,
Yes,
right? And your brother, that's Alexis's dad.
correct.
And so you and your brother and Alexis all went to the police station and talked to the detectives after this incident.
That is not correct. My husband, Timothy, and myself, and Alexis and her husband went. My brother did not go.
Okay, your brother did not go. Got it.
Yeah.
Okay, so her husband.
No.
So-
Yeah.
Okay, so let's I was trying to set the stage here.
Oh,
That's
sorry.
all I'm trying to do.
Sorry.
Just to make sure that we all know the time that we're talking. Because as y'all are talking, just so that we know, as you guys are talking to the detectives, you're in a group together. You would agree with that?
Outside in the lobby?
Yes.
Yes.
And whenever, because we have body cam of you on the body cam. But I just want to set the stage that when other people are talking in this group, you all are there present for everything that's being said. Does that make sense?
Sir, I didn't enter that meeting that they had. I was not present for that.
I have you here talking. I have Daisy Nieto talking about some of these things. Do you remember being in a situation where you were talking to detectives?
At my mom's home, yes,
Maybe
sir.
at your mom's home.
Yes, not at SAPD
Okay,
headquarters.
maybe at your mother's home, right? But y'all are all in the same group. That's all I'm trying to.
Yes, sir.
Okay.
Sorry, I was a bit confused because
Yeah, no. There was kind of several different times that things were going on. But do you remember? Just gonna go through a little bit and find that. Do you remember Alexis telling the detectives that she hadn't really spoken to her mother in a few months? It had been months since she had talked.
Yes, I remember that.
And that they were kind of talking about how they had to kind of distance themselves because of her behavior, because she was not herself, basically.
I think that is correct, sir. She distanced herself, and we had a lot of conversations about this, but Alexis had a very difficult time grieving her mom to this mental health illness. And so there was a lot of times where, we had conversations about healthy boundaries. And again, it's not deemed as an abandonment. I really feel that it took a toll on Alexis, her well-being, to see her mom in this mental health decompensation process, to take on her brother and have 2 children under 4 years old. And so it was a lot for her. But yes, sir, she did say that.
Yeah, no, and the point, I just want to make it clear, I'm not criticizing Alexis for that. It had to have been extremely difficult. There was a time, I think, when the idea was maybe Melissa could live with maybe one or more of y'all, like with her family, right? I mean, that was attempted.
She did live with Melissa. So after the Oxford home, Melissa, while she was at the Oxford home, Melissa was very independent, by the way. So she lived with other residents there, and there was rules, and they cooked there. They did a bunch.
Judge.
All right, let's go ahead and take a short break.
Thank you.
All right.
All right, welcome back, members of the jury. I figure we'll need at least one more break, at least, possibly two, but I'm going to let y'all tell me when. As soon as I get from any of y'all that you need a break, we'll take one. All right. Where we last left off, defense?
Thank you, Judge. May I press the witness?
Yes.
Ms. Nathaniel, I'm showing you Defendants 108. Can you tell me, when you talked about your, I guess you talked about the USB drive that contained like a lot of the, or the CPS, did it look similar to that when you were reviewing it?
Yes, sir.
Okay, and this comes out of like page 338. Do you see that? You see that little green flag there at the bottom?
Yes, sir.
Okay, the line above it.
Yep.
You don't need to read it out loud. If you could read it to yourself.
Yes, sir.
Okay, and then if we can turn here, this is kind of a continuation. If you could, I guess, read here where I'm pointing, just to yourself.
Yes, sir.
All right, and just so that we can get a clear frame of reference, you see the name of the person that was being interviewed?
Yes.
And age?
Yes.
Okay. Because we were talking about the age. So the document I showed you, it's part of the CPS records where they interviewed Dylan Perez, right?
Correct.
And that's Melissa's little boy.
Yes.
He was, at the time, he was 7 years old.
Correct.
And the purpose for this, because, you know, as this is going on, this is kind of December sometime. And I think you guys talked about the fact that this was when, you know, things were getting to the point where Dylan wasn't going to be living with her anymore.
So there's two occasions, sir, in December. The first December, what year is that, sir?
This is 21.
21,
So this
yes.
would be the year before?
Yes.
Okay. And CPS had been called out the December the year before.
Correct.
And I guess, were you involved with the family at that time? Did you know that CPS had been investigating?
No, my true intervention with Melissa started, family intervention, started the day I saw her on May 29th of 2022.
Okay.
That's the day I started intervening and that process started, what I explained earlier.
And so you would agree that there is a whole lot of history about her that you weren't necessarily familiar with until you read the USB and kind of went through that information?
Correct.
And so in this thing in particular, what Dylan told the caseworker is that his mother would whisper into his ear, "I'm going to kill you," talking to the man in his ear.
Correct.
And he said it scared him because he thought she was talking to him.
Yes, that was
Going into his ear.
That was information that was relayed by, at that apartment complex, Dylan was already with Alexis. So it was information that was relayed by CPS to Alexis, I believe.
Sure, and I mean, and obviously it's a concern because a little boy like that hearing his mom say that in his ear would be hard.
Absolutely, sir.
And he also talked about the fact that he witnessed his mother attack the neighbor, right? Assault her.
Right, because her security delusions made her believe that her kids, something was wrong with her kids. And so she was on a mission to find her kids, or I don't know. I can't speak for what happened, but I know that it's centralized in some of those things.
No, honestly, I think that I think from seeing, I've probably seen more, or read it probably more deeply than you have. I don't know how much time you've had with all this stuff, but I think your presumption is right. I think her delusions drove her, especially the persecutory delusions, dealing specifically with threats to her children or family members or other things like that, drove her to commit violent acts against other people. As we now, assuming the person on the bus is true, that's one, right?
Yes, sir.
For kidnapping her children, I think went over to the neighbor's house because she thought that the neighbor had her kids in their house or their apartment or something.
Yes, sir.
Right. But the little boy Dylan, the 7-year-old little boy, saw his mother attacking this woman, and he said pulling her and yanking her by the hair and everything else, right?
Yes.
Okay, and so it goes back to though the woman who did not have her children, did not have Melissa's children, did not have anything to do with her. That's still the same threat to her. Just because Melissa's having a delusion doesn't mean it's any less dangerous for the woman being attacked. Do you see what I mean?
Yes, sir.
Right. Because even though somebody may have schizophrenia or may have a delusion, if I have a delusion that you've stolen my children and I need to kill you for it, I'm just as dangerous to you as anybody, as if I didn't have schizophrenia, right?
Yes, sir.
So, I kind of like to go back to some of the things when you guys were talking to the detective, I can see that, and I think probably because of your position, that your role in the family and kind of dealing with this is kind of interfacing about the medical stuff, because that may be something that you know more than Alexis does and maybe some other members of your family, right?
I mean, they would reach out to me to get some guidance.
Sure, and you would try to explain, like, when you're talking to police, you want to get her ED'd, so you're explaining the things that needs to be to ED because you know what those things are, right?
I know to use key terms.
Sure.
To expedite
Sure.
care for individuals, yes.
And I guess that's what I mean, because in my family, if anybody has a legal question, I'm the one they text and call, and I think that you were probably serving that role as far as Melissa's mental health in your family.
Right.
Okay, so one of the things that when you're talking to the detectives after the incident, I think you're trying to go through and explain, and you're talking about the fact that that she's been having schizophrenic episodes and paranoia, and you said hallucinations, auditory, tactile, like all kinds of stuff. Now, so if you could please explain to the jury what you mean by that.
She was having auditory verbal hallucinations, and so typically when you have those hallucinations, the voices can be pleasant, they can be rude at times, they can be abusive, agitated, and so part of her her symptoms were that she had auditory verbal hallucinations. Often tactile means like she often felt like something was nudging at her or like picking at her. She would see things or claim that she was seeing things that we were not seeing, right? It clearly more on the visual side, like she was adamant that somebody was in the attic or things like that, of that nature.
And one of the things, going back to kind of what you were reading about, what Dylan was saying, is that she was telling Dylan that there was somebody in the attic that was going to cut their head off, or cut her head off, right?
Yes, sir.
And so, a person experiencing that, those are pretty significant symptoms of schizophrenia.
Yes, sir.
To have all of them going on, plus, the delusions, plus the persecution delusions, paranoid delusions, auditory, visual, and tactile hallucinations, like it's a pretty extreme form of schizophrenia.
Yes.
Yes. And so, I guess as you're explaining those things, and thank you for explaining that, but as you're explaining those things to the detective, Detective Dorsey says, was there any physical violence with any of this? And Alexis said, well, she was like, whenever she would get questioned, she would automatically react, you know what I mean? Like she asked, you know what I mean? She was an aggressive person. And then Soto said, okay. And Alexis said, okay, so I guess. Answering Dorsey's question, she's violent. What she's saying there is that if somebody would question Melissa, if she were being questioned, that she would get very aggressive about being questioned. Does that make sense?
I mean, if that's what she said, sir, then that's her assumption of her mom. And I truly believe too, and thank you for bringing that up, but I truly believe that Alexis was in the stage of shock and denial when she learned about her mom's violent death. And so there's a lot of things when you experience someone that dies in a very tragic manner, like the first stage of grief is shock and denial. And I really feel that there was a lot going on with her. But sir, if she did say that, then that's something she said, sir. I can't deny whatever she said.
Well, I mean, and honestly, you know, in the situation as it is, I mean, I agree. That's a shocking thing to talk about, to go in and, you know, be talking to a detective. But I think what she's trying to communicate is that my mother is the type of person that if you question her, she gets aggressive. She gets upset about it, right?
Again, if that's what she said, then yes, sir.
And in fact, you know, and then she, like you actually, when you were there, you asked like, how are the officers doing?
Absolutely.
Yes, and they said they're fine. And you said they have hard jobs.
I do, yeah. And I still stick with that, sir.
Well, yeah, you know, and there's a lot of things about what had happened that night, as you said, like that you weren't aware of. Like, I don't know, maybe I'm wrong, but I think until this point of you on the stand, I think that you believe that they were called out for a mental health call.
Sir,
You didn't know?
I didn't know.
Okay. And because it just seems like that's kind of what we do know now, what Melissa was suffering from.
Right.
But we didn't know, none of them knew then.
Right. The only thing I do remember from some of the raw footage that was shown to me was the first responding officer that was out at the scene asked her if she has any form of mental health illness, and she said, I have schizophrenia, but I don't think I do.
She said she was like falsely diagnosed or something.
Yes, something along those lines.
You're correct. And guess, I'm with you. That first officer, he heard her delusions. He believed that she needed to be ED. He started walking back to his patrol vehicle and let her run off, right? And so he didn't arrest her, he didn't put her in handcuffs right there. But I guess what I'm saying is that officer, that first one, who's still out there on the streets right now, that first one never updated the system so that when these officers responded to her hammer attacks and her candle attacks, they didn't know that she had experienced any of that. You know what I mean? And so and I'm not saying that to you for any other reason, but just to let you know that it's different. What's actually happened was different than what has been kind of maybe perceived as happening. But that doesn't make your loss any less, right? I mean, you're going to miss her, and her daughter's going to miss her, and her children are going to miss her forever. And we don't minimize that. But we do want to make sure that we have all the facts right about what was going on. And I think that ultimately the safety plan, like the voluntary safety plan that you were talking about. I mean, I guess it's important for us to delineate that CPS came out and thought that her son would be in danger if her son stayed there at her place, and you would agree with that?
Yes, sir. I actually called Family Protective Services myself after I learned that.
Right.
That he was that December of 2022.
When she wasn't bringing him to school anymore because she was afraid for him.
Yes, sir.
Because, you know, and I'm sure that you've seen this, you know, sometimes with those types of delusions, they can stop being about, for instance, in schizophrenia, sometimes they can start to have delusions that demons are wearing their children's faces, and they have to get the demon out of the child. You've seen that?
I haven't seen that, sir.
You've never seen any kind of delusion where the person is not who they appear to be, but there's somebody else?
No, sir.
So it can happen. And so my point being that if somebody has lost touch with reality, then they can potentially be a threat or a danger to other people around them. You would agree with that?
Objection, Your Honor. Calls for the witness to speculate. She has said she has not heard that counselors persist in that same area. She has no knowledge of it.
Yes, Your Honor. I mean, I can withdraw that other one. She did say she didn't hear that, so I'm moving to this next one.
Okay.
Thank you, Judge. Yeah, I guess what I'm saying is just in your experience with people who have schizophrenia, if they have lost touch with reality and they've lost touch with if they're auditory, visual, persecutory delusions. Persecutory delusions can also be, they can have command delusions, and you're aware of command delusions as part of schizophrenia?
Command hallucinations?
Command hallucinations, that's right. Thank you. Command hallucinations. Your auditory command hallucinations.
Yes, sir.
Kill this person. hurt this person, hurt yourself, commit suicide, do whatever. People with schizophrenia can experience those.
Yes, sir.
Right. And so I guess my point being is that somebody who is going through that is no place for a 7, 8, or 9-year-old little boy to be,
That is correct, sir.
because it's a potential danger to that child. Right?
Yes.
And to anyone else who may not be able to fend for themselves, anyone else who might be present there when she's in that state. You would agree?
I would agree that that a child should not be around an individual that's struggling with symptoms that are, as what you're mentioning.
Sure. But I mean, also, I think you would also agree that somebody like your mother, you were worried about her, and she should not be around somebody like that.
I was concerned about her, but I wasn't afraid that Melissa was going to harm her because she had never harmed her. She had never harmed any of us.
And that's the thing, and she had never harmed that person on the bus until she did, and she never harmed, the lady, the next door neighbor, until she did, until her delusions made her believe that it was necessary to harm her. Do you see what I mean?
Yes.
Right. So with somebody with schizophrenia, their past actions are not necessarily predictive of their future behavior, because schizophrenia is an unpredictable disease.
Sir, I just want to be careful that we don't overgeneralize all individuals with schizophrenia.
Absolutely.
We don't want to stigmatize that population. So not all of them, a vast majority of them are high functioning.
I agree with you. And the ones that are high functioning most of the time is because they're on their medication.
That is correct, sir.
That is correct. And so the ones who don't take their medication, who have symptoms these severe, that's all I'm saying. That can be unpredictable. So their past actions are not necessarily predictive of their future behavior, because the disease itself, when it comes out in this way, is unpredictable.
I think any mental health illness is unpredictable.
Sure, but specifically a mental health illness where the person is not in touch with reality, or they're experiencing auditory, visual hallucinations, persecutory delusions, those kind of things that that she was experiencing, those can make a person more unpredictable because you don't know what's going on in
Yes,
their mind, right?
Yes.
Okay. Thank you again. I'm sorry. I'm sorry for what you're going through, and I know it's going to be hard, and I appreciate you answering my questions. I'll pass it on.
Thank you, Mr. Gosh.
May I proceed, Your Honor?
Yes.
Good afternoon, Ms. Nieto.
Hi,
My
sir.
name's Mario Beltrado. I'm sorry to meet you under these circumstances. I know this is tough for you and your family, okay? I don't have a lot of questions for you, but I do have some that I've got to go over, okay?
Absolutely.
One of the first things I want to say is, I think a lot of us have had relatives or friends who maybe suffer from mental illnesses or drug addictions, and sometimes they can overlap, right? And a lot of times families do the best they can, but sometimes they fall short. Would you agree with that? Because it can be frustrating. Sometimes the people don't even recognize that they have an illness, for example. You're familiar with that, right?
Yes, sir.
Okay, people who have, and I know I keep forgetting the term, somebody who has maybe something like schizophrenia but doesn't recognize it or denies it, the medical literature says, well, that's a particular issue in and of itself, because they're saying, I'm fine, I don't have anything, like Melissa was saying initially to the first responders out there, okay? Now, when people feel like they don't have a problem, or maybe you get them into help like you do, and kudos to you for doing that and the family, but sometimes people they'll stop taking their medication, right?
That is correct, sir.
Okay. And a lot of times they stop taking their medication because they don't like the way it makes them feel, right?
Yes, they prematurely discontinue medications because of the side effects, or because they feel like they feel better. At some point, they feel like they're doing a lot better in their recovery.
Right, because maybe they don't have the self-awareness to know that this is actually, all things considered, much better for you. Would you agree with that?
Can you rephrase that, sir?
Because sometimes they don't have the self-awareness to realize that taking the medication is better for them in the long run.
I think that sometimes they are fixated on side effects. Like the feeling of when you're not feeling well, or any medication that you're on, if it makes you feel a certain way, then you don't engage in that medication. You don't want that type of medication.
I think that when you first, one of the first things you said in your testimony was you first became aware, I think in February of 22, that there was an issue with Melissa, correct?
Yes, sir.
Okay. Because you knew, and I think you testified to the jury, that you were aware she had a series of emergency detentions, correct?
Right.
Okay.
Collateral information.
Okay. I'm sorry to interrupt you. And the reason an emergency detention is done is because law enforcement feels like the person is a danger to themselves or to someone else, right?
That's correct, sir.
Okay. And your family, including you, have called more than once for an emergency detention for Melissa, correct?
Right. We were on a mission to get her stabilized so that she can reunify with her kids and be the Melissa that we knew.
Okay. But one of the issues is, like, the May 26, 2023, when you called, when she goes over to your mother's house on Madrid Street, right? And you're telling the 911 caller you want an officer to go out there and check on her because you're concerned for your mother and you're concerned for Melissa, because this was on, your mother had her on speakerphone, so you could hear what Melissa was saying to her, right?
I could hear the loud tone of voice.
Okay, and you could hear Melissa saying to your mother that the FBI is listening to me and they're after me, right?
She showed up at my parents' house because she wanted to let my mom know that the FBI was listening to her, and my mom has like an attic in her dining area space, and she was adamant that there was something there, and so she wanted to make sure my mom knew that, you know, that she was looking out for her. But it wasn't because she wanted to harm anyone there. It was out of her, in her own way, like a caution to my mom, like, just be careful. It's almost like she was trying to take care of my mom, if that makes any sense.
And Your Honor, I'm sorry, is it okay if I stand up? So, thank you.
Yes.
Because these entities, I think they've been described, she was afraid that the entities that were persecuting her and her children might be after your mother, right?
Her delusions always centralized around the safety of our family.
Right. But with regard to your mother and the attic, okay, she was worried that those entities might be there after your mother, right?
That they were going to harm my mom.
Okay.
Yes.
And are you aware in this particular case that, you know, on June 23rd, 2023, that all of the vents in Melissa's apartment were covered up?
No, I was not aware.
Okay. But you're aware that when you first became, when you, and you just didn't call 911 for emergency detentions, you also reached out to CPS yourself, and I think you just said that, correct?
Yes, sir. I'm a mandated reporter, but first and foremost, I was always going to look out for the well-being of those children and of Melissa.
Right. Because your primary concern, because in December of 22, there was only one child left with Melissa, and that was Dylan, correct?
That is correct, sir.
Okay, and both you and Alexis were primarily concerned with Dylan, correct?
When the social worker from that district contacted me, I made sure that we secured his safety.
Okay.
Yeah.
And that's when you found out that Dylan was telling the police officers and the CPS personnel, the CPS investigators, that his mother thinks that there are entities in the vents, and that she actually had a bunch of knives out on the counter to protect Dylan from the entities up behind the vents, correct?
That is true.
Okay, and these entities behind the vents, they were going to chop his head off and chop her head off, right?
That is correct.
Okay, and actually then, she would actually whisper, the school personnel was even aware of this, or the social worker, she would actually whisper into Dylan's ear, who was, 7 or 8 at the time, you better get out of there or I'm going to kill you.
That is true.
Okay, and I guess it's fair to say that that would scare any 7 or 8-year-old to hear his mother telling him that, correct?
That is true, yes, sir.
Okay. May I approach?
Yes.
Ms. Yento, I just want to sort of orient the jury, if we could, and let me know. Melissa had 4 children. Alexis was the oldest, correct?
Correct.
And then there was...
There was...
Yeah, he needed, you can't see the color.
Oh,
I got a better marker.
disappearing ink.
Yeah.
So he's got it.
Okay. Thank you. Appreciate it. So Alexis was her oldest, correct?
That is correct, sir.
Okay. And then there was
Aiden.
Aiden. Is that A-I-D-E-N?
Yes.
All right, okay. And then,
Jaden.
and if I'm misspelling it, I apologize.
Okay.
Okay. And then finally Dylan, correct? Now, Alexis's father was, and you can just give me the first name. Who was Alexis's father?
Antonio.
Okay. And was Antonio the father of Aiden?
No, sir.
Just give me the first name. Who was Aiden's father?
It was Mr. Reyes.
Okay. Reyes? Okay. With regard to Jaden?
Mr. Reyes.
Okay. And then finally, with regard to Dylan?
It's Guadalupe.
Okay. Now, as far as we know, Antonio lives here in Bexar County?
Yes.
Okay. What about Mr. Reyes?
He also lives here.
Okay. What about Guadalupe, Dylan's father?
Guadalupe lives in Mexico.
Okay. Okay. So he wasn't around and involved in Dylan's life. Is that fair to say?
He is involved in, he was as well,
Okay.
communicating with him.
Okay.
through
Okay.
Calls.
Now, and Alexis, she left Melissa's home at a pretty young age, correct?
During high school, like senior year.
Yes. Okay. And with regard to Aiden and Jaden, you attended, because I know you contacted CPS. You actually attended some of the family meetings that Child Protective Services had with the family to discuss all of this, correct?
One meeting, yes.
Right. And that was in January of 2023,
That
right?
is correct, sir.
Okay. And you're aware that, or tell me if you're not, but that Aiden and Jaden, their father and his wife, were so concerned about them being with Melissa that they removed them and they never took them back. You're aware of that, correct?
From the CPS file that they gave me, the USB drive, I learned that, yes.
Okay. Because they were present for the family meeting along with yourself and Alexis, correct?
They were not there.
Okay, but you're aware that that happened, right?
No, sir, that did not come up in the meeting.
Okay, are you aware that Mr. Reyes said he took the boys out and he never let them go back to live with Melissa?
I am not aware of that.
You're not aware of that, okay. Are you aware that the Reyes were concerned because there was drug paraphernalia, like needles, to use methamphetamines all over her apartment? Were you aware of that?
Objection,
I don't know. That
I'll
part.
sustain.
Sir, I learned that through the USB drive.
Okay, okay.
I don't know that information.
And with regard to Dylan, you were aware that Dylan was put into therapy after his experiences with Ms. Perez, right?
Yes, sir, I actually helped with that process.
Okay, and thank you for that. And you're aware that Dylan did not want to go back and live with his mother, right?
That is true.
And you followed up with CPS. You were so concerned that he might be sent back that you would actually send them emails saying, hey, I want to make sure he doesn't go back because he'll regress, correct?
That is true.
And as a matter of fact, Dylan was aware, he could identify drugs and he was aware that his mother was using drugs, correct?
I didn't read that, sir.
Okay, you didn't see that in the CPS records?
No.
Okay. Now, stepping back for just a second, so when you would contact the San Antonio Police Department when there was a need for an emergency detention, you and your family loved Melissa, that's fair to say, correct?
Yes, sir.
Okay, and she loved y'all, right?
Yes.
Okay. But in spite of that, as you told them on May 23rd, 2023, she would get aggressive and she's going to fight us if we try to take her to the hospital.
That was in 2022, not 2023.
I'm sorry, 2022, yes.
Yes, sir. As I mentioned earlier, when I'm calling, dispatch is always asking crucial questions, and I was not afraid for my mom's safety nor mine or anyone in my home. I was on a mission to get her ED'd.
Sure.
So that she could be stable. And so when you're asking if I was aware of like her, what was your question again?
But my question is, when you needed that intervention when you needed to get her help, you said, we can't do it on our own because she'll get aggressive and she'll fight us.
Yes.
That's fair to say, right?
So, not physical fight. It would be an argument, or she would not be receptive for us to take her to the hospital. But I never was afraid of her physically fighting me or my mom.
But it's fair to say when you or your family needed that help with regard to Melissa being a danger to herself or others, you would call the San Antonio Police Department.
Yes, because they are trained and they have specific training, CIT training, I believe, to de-escalate. They ask crucial questions, and we had successful EDs in the past. We had officers that responded that took their time to ask questions that were of great help to her, and we had successful outcomes to those EDs. So she had never been put in a position like that.
You're aware she had multiple emergency detentions, correct?
Yes.
Okay, and multiple hospitalizations, correct?
Correct.
Okay. And at that family meeting in January of 23, as a matter of fact, you said that you weren't going to enable her anymore by giving her any more money because you were frustrated with the fact that she wasn't going to the psychiatrist you had set her up with anymore, right?
Sir, I never said frustrated in those comments.
Did you say, I'm not giving her any more money to enable her?
I decided not to enable her because up to that point, I was paying rent. I was Ubering her to places. I was buying her medications, picking up her medications, dropping off her medications. And it's one of the most difficult decisions that people make. And when they have family members that are experiencing mental health illnesses, it's by far the most difficult decision to make, to stop enabling them and empowering them to use the tools in front of them to get better. And so it was a healthy separation, and it's not uncommon for someone to say, okay, up to this point, we're no longer going to enable, we're going to empower. And that's what I did, sir.
When was the last time you physically saw Melissa Perez before her death?
I saw Melissa in January.
Okay, so 6 months before her death?
5 months.
5 months, okay. Now, when the last time you called for the assistance of the San Antonio Police Department in May of 22, by the time the police got out there, Melissa had already left your mother's home, correct?
Yes, and so, as I mentioned earlier, my last time seeing her was in January, but the entire time, she still had contact with my mom, and so therefore she would show up periodically. My mom would, she would show up, my mom would feed her, my mom would give her food to go. So she wasn't completely abandoned throughout, at the end of her life.
That, when you saw her, when you called in May of 22, she was not at the home when the police showed up, correct?
That is right.
Okay, now, you knew where she lived at the time. You knew she was living at the Rosemont Apartments, right?
Right.
Okay, you knew the address of the Rosemont Apartments?
Yes, sir.
Okay. Now, the police officers who, and this was about what, a month or less than a month before her death?
Correct.
All right. Did you ask, can you guys go out to her residence at Rosemont to do this welfare check? Did you ask that?
No, I did not.
Okay. Do you know, to your knowledge, did her daughter Alexis say, hey, my mother was out here, she's suffering from visual and audible hallucinations, can you go check on her? Do you know if she did or not?
Sir, what I do want to stress is that...
Samantha, I'm not trying to be difficult, but I just need an answer. Do you know if she requested a welfare check on her mother that day?
We were in contact with the Family Protective Services Department, and they were making efforts to do those home visits.
Okay.
So,
do you know if anybody followed up with SAPD and said, can you go out to the Rosemont Apartments and check on her? Okay. Did the officers who showed up that day, they go to the home on Madrid and they say, she's not here, but we're aware the family says she's a danger to herself or others. We can go check on her at Rosemont if you tell us what her address is. Did they volunteer or offer that assistance?
No, sir. By the time they got there, she had already left. And so she was down the street somewhere, and my sister went to look for her and told the officer, she's down the street at this bus stop, can you please go and no one followed up, I guess. I
So
don't
the
know.
officers did not do that?
No, I don't know, sir.
Okay, and to your knowledge, they didn't go out to her address that was well-known on Rosemont to follow up on it?
No, sir. Otherwise, we wouldn't be here, right?
Right. Okay. And in that family meeting in January of '23, and I know things can get frustrating when you're trying to help somebody, and y'all were primarily focused on helping Dylan. Do you recall Alexis saying, hey, I kind of got to step away from this and just concentrate on Dylan, I can't be helping her anymore?
Yes, she made the difficult decision to have a healthy boundary, to set a healthy boundary, which I supported because I knew how difficult it was for her to be witnessing what she was witnessing. And again, she was grieving the loss of her mother to this mental health condition. She had 2 toddlers at the time. She was also taking Dylan in for the second time.
And nobody's faulting you or Alexis. I mean, you do what you can. But even when when Melissa lived with Alexis for a short period of time after you got her help and she was on medication, even on the medication, she was still hearing voices, correct?
Yes.
Okay. Now, when you said that the state gave you a USB with all the Child Protective Services records. It is about 900 pages. Does that sound kind of correct as far as how many pages were in the records?
Sir, I only got 4 files and they weren't 900 pages.
Okay. But they did provide you with all the police reports in this case concerning Melissa Perez as well, correct?
I'm not sure if they're all, but there was some in there.
All right. Was there a report in there where she was accused of assaulting a woman and threatening to burn the woman's apartment down and she had a can of gasoline with her?
I don't recall reading that.
Okay. Now, Mr. Goss was asking you about command hallucinations. And like I think you gave the example, when she was on the bus and she got into some sort of assaultive conduct with somebody on the bus, the voices in her head were telling her that those people had her children, correct?
That's what she reported to the officer.
Okay.
I wasn't there, sir.
Okay, now, are you aware of seeing another report, and I think this concerns, and if you want, I can show you, this is the February 2022 emergency detention of Melissa Perez, where she went up to some man's home, knocked on his door.
Objection, Your Honor.
Okay.
Could he prep and show the witness that she recognizes it?
May I approach?
Yes.
Do you recall seeing this emergency detention from February 2022, which I think said was the first incident that brought this to your attention?
I've never seen this document, sir.
Okay, no one's ever showed you, the state didn't show you this document?
No, sir.
Okay. So did anybody bring up the fact that she had threatened a man with a baseball bat?
Objection, Your Honor.
I'm testing her knowledge. If they hadn't-
I don't know, sir. I've never seen that document.
Okay. On the day of her death, the next day, that day, when the detectives went out to your mother's home, okay, did you know the individual that was living with her?
I found through the USB drive, I learned it was potentially, well, I'm not sure if it was the brother or, I don't.
Well, is it fair to say that neither you nor any other member of the family knew there was anyone living with her?
I did not know there was anyone living with her.
And I guess it's fair to say y'all didn't know who that individual was either, correct?
I learned about that individual at her funeral service when her neighbor mentioned to me that she was trying to help someone in a wheelchair and that she washed his entire wheelchair and she like cleaned him up because she wanted to help him. So that's Melissa, like she always found a way to help someone else despite her situation.
And my last question, Nieto, is you reported to CPS you were concerned about Dylan because Melissa would often have people stay at her apartment who were abusing methamphetamine while Dylan was still there.
So I learned that after when they picked up Dylan, when she signed the paperwork, she went to get ED'd that day, and we learned that there was an individual there, and that individual is her brother, or was her brother, and I knew history of him. So yes, I was going to advocate for my nephew and make
Sure,
sure.
and I appreciate that, but isn't it fair to say that you told CPS there were two individuals who were known methamphetamine abusers in her apartment at the same time Dylan was there?
Yes, because I had received information that there was another individual there visiting.
And, I said that was my last question, so I won't
Yes.
ask anymore. Thank you.
Good afternoon, Ms. Nieto. On behalf of Alfred and his family, we're very sorry for your loss, and
Thank
I have
you.
no questions for you.
Thank you, sir.
Miss Daisy, when was the time frame when you testified you had to step away and stop enabling? About when was that?
That was in January, the day before her birthday.
So January of 2023. The lease for the apartment, is that in her name or yours?
It was her name.
And if you know, how did she make her rent?
Melissa used to give plasma to make ends meet, or if she was short on money, I would pay her rent. I would get a money order and pay her rent. I had initially, Melissa has a younger sister, and I often called her too, and she would pitch in to help her. It was a joint effort. I think all of us tried our best to help her. So yes, sir, she paid her rent at times with whatever she made, or if she was working at Bill Miller's, or if she was working cleaning offices, she would pay her bills that way.
Thank you, Your Honor. No further questions.
No questions.
No questions?
All right. Make sure you don't talk to anybody about your testimony related to this trial or any other potential witnesses in this trial and their testimony. That's going to apply to the end of the trial, and you can talk to the lawyers about whatever you need to, other than the evidence in this case, okay?
Okay, sir.
All right, you're excused.
Thank you.
All right, State.
Your Honor, State would call Detective Ronald Soto.
Swear you in. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may need to adjust the microphone. Make sure everybody can hear you. Introduce yourself to the jury and spell your name for the court, please.
Detective Ronald Soto, San Antonio Police Department, work in the Homicide Unit, SOTO, my last name.
Ronald, R-O-N-A-L-D?
Yes, sir.
That's the right way to spell that name.
It is.
Okay.
Sir, how long have you been an officer with San Antonio Police Department?
I've been an officer for 21 years.
And if you could briefly outline what those 21 years have entailed, how long were you on patrol, et cetera?
Yes, sir. Yeah, I was a patrolman for about 10 years. I promoted in 2015 as a detective. I briefly worked in the crime scene unit for a few months, and then from there on I moved to the night detective unit, and then to the homicide unit about 3 years ago, a bit over 3 years ago.
And I apologize, how many years were you a detective before you promoted to homicide?
About 6.5 years. So I've been a detective for a little over 10 years.
All right. And you've been in homicide for how long?
For about 3.5 years.
And approximately how many homicides have you been lead investigator on in those 3.5 years?
I would say about 24 homicides.
And how many of those, how many officer-involved shootings have you been lead investigator on?
About 8 or 9, I think.
And what was your role as regards this case today?
I was the lead investigator in this case.
At the time, June of 2023, had you been lead investigator for an officer-involved shooting before then?
No, sir, that was my first one.
If you would please, how did you get alerted or notified about the events that took place on June 23rd, 2023 at the Rosemont Mills Apartments on Old Pearsall? How did you find out?
I was called by my sergeant, Sergeant Chad Wedicking, I believe, called me up that morning and informed me about the incident that happened there that morning.
Okay. What did you understand it to be? Did he go?
He didn't get into too much detail. He just said there was a shooting. Someone was shot inside a house. Officers were involved with the incident, but he didn't go into great detail on that at all.
So you knew it was an officer-involved shooting?
I knew it was an officer-involved shooting, yes, sir.
Okay. And did he call you because you were the lead?
Yes, sir.
Okay. What's the first thing you did?
When I arrived, I'm going to guess about an hour later, maybe I'm just approximating that time. First thing I did is I contacted, usually what I do is I try to talk to the detectives out there, usually night CIDs out there. But in this case, since it was an officer-involved shooting, I think I spoke with Lieutenant Paduica first. He's the night CID lieutenant, and I think the sergeant was Sergeant Brasenio Rivera was also out there. I think those are the two people that I first talked to when I made the scene.
You remember about what time you got there?
I'm gonna say maybe an hour after it happened. I'm just, like I said, I don't know exactly what time. Usually within the hour. So I'd probably say after 3 sometime. Yeah.
To your knowledge, had there been a warrant obtained?
The only thing I knew when I got there was I think there was a search warrant obtained by night CID.
So you're able to get inside the apartment?
Yes, sir.
Did you write that warrant?
No, sir.
Do you know who or what section of the department generated the warrant that enabled you to get inside the apartment?
Yes, sir. It was the night detectives. I think Detective Bjork did that warrant.
Okay.
From night CID.
What was going on at apartment 3102 when you got there? And I believe you testified sometime after 3 o'clock in the morning.
Yes, sir. After being briefed by the lieutenant and the sergeant from night CID, we started walking toward the apartment where the incident took place. And I think, if I remember correctly, crime scene was in there, was working it. They had stuff tagged already, I think outside and inside the apartment.
Okay. And so both outside and inside. So you were able to go inside the apartment?
Yes, sir. I was able to walk inside.
Okay. What, if you can, tell the jury, what were your initial well, let me rephrase. Was the body still there?
Yes, the body was still there.
All
Right.
What were your initial observations, given the information you got from your sergeant?
My initial observations as I'm walking up, I noticed, I see the shell casings, multiple shell casings outside in the grassy area, outside the patio area, and then there's also some evidence inside the patio area. And then I went inside, and that's where I saw Miss Perez, where her body was still there.
Yes.
I apologize, I didn't mean to
Well,
cut you off.
no, I was gonna say that just a preliminary, as I was walking up on the scene, there were some concerns, just in general, just seeing that everything was outside, and then she was inside the apartment. I didn't jump to any conclusions, nothing like that, just concerns, that's all.
May I approach, Your Honor?
Yes.
Detective, I'm showing you what has been marked as State's Exhibit 28C, or Charlie. Do you recognize 28C?
Yes, I do.
And what is on it? What's the diagram?
It's of the apartment, where Melissa's apartment, where the incident occurred.
Okay. And so, where's the entry? And if you can sit down, point.
Okay.
Where's the entry? The front door. All right. And so this area here, what is that?
That's the patio area.
Okay. And I believe you testified that when you first came in, and that figure here is the body.
Yes, sir.
So the body is inside the apartment?
Yes, sir.
And where did you see the shell casing?
On the outside. On the outside of the patio area, and also some on the inside.
Okay. And so that was your first observation?
Yes, sir.
Did you observe the evidence technicians going about their tasks?
Yes.
My apologies for the court, Your Honor. You're okay. Did you recognize any of the evidence techs that were working that night?
Off the top of my head, I'd be guessing. I don't know, maybe Yvonne Diaz, I think, maybe. I can't remember, I'm sorry.
Did you ultimately produce a report or an investigative guide about the investigation you began at 3 in the morning on June 23rd, 2023?
Yes.
Would having a copy of your investigation help to refresh your recollection and support your testimony here today?
Yes, sir.
May I approach you?
Yes.
Detective, I'm showing you what has been marked as State's Exhibit number 193 for identification. What is 193 for identification?
That is my prosecution guide.
Take a moment, flip through it, see if it appears to be complete.
Yeah, everything appears to be there.
Apologize for this. Your report, it's unnumbered, correct?
Yes, sir. It's not numbered now.
If, just to support us, if you would take a moment, number the pages so we can both know, speak from the same page that we have to refer to.
Okay.
While he's doing that, my report is actually at page number, so I would just like to go to check his too, just to, so I'm just gonna the number of pages. Check that one. You got that one.
Your Honor, for the record, I think there's one version of this that was entered in Mark 43, and then there was another that was a prosecution guide that had an attachment, final investigative supplement of file, which was signed off by the chain of command. I think State Exhibit 193 is actually the final investigative supplement for file, chain of command signatures, and then the prosecution guide. Mr. Goss has for
Yeah, I do, so, yeah, Judge, that's correct. There's actually two different ones. One's had page numbers and one doesn't. I have them both, I just didn't know which one to look at.
That is correct, Your Honor. It's the one signed off by the chain of command. That's the one he authored. The other is a compilation of all the subordinate reports put together and has the body of his investigative guide in typeface with the SAP headings, etc. But they are virtually word for word. I'm just simply saying he authored this, and that's what I'm going with.
I just have a request for a very, very, very short separate break. Very short.
All right. Members of the jury, let's take a short break.
All right, for the jury.
potentially, maybe intentionally or not, but try to elicit information from this witness that Sergeant Flores ordered Salinas to go in the window, or, Salinas called Night CID, and I just want to remind the court that because of the issue that we had with Salinas, that Detective Thornton from Night CID was not able to testify about those issues, and so we just asked to make sure that no hearsay is elicited from this witness that what has already been excluded by the court. And so that
is understood, Your Honor.
Yes, sir. Thank you.
Okay. And I assume the witness has been so instructed by the state. I don't know if that inquiry can be made.
I will so instruct right now, abundance of caution.
Okay.
Well,
And even this warrant, the warrant is for an assault on Salinas. And every officer is responding from that E-tone. They know he got struck. I'm not going to talk about the legal entry, but how do we suggest we generate the E-tone?
I think first the E-tone was generated because Salinas had somebody at gunpoint, and he got hit with the candle after, like immediately after the E-tone went off. But I think that we can do that. The fact that they all are there and everything else, that's one thing. The only thing I'm concerned about is in his report that he has up there, he says multiple times that Salinas called Flores and said, I'm going to go in, and Flores said, okay, go in after or whatever, and none of that was testified to and it was excluded. And so I just want to make sure that the witness does not try to put that in there based on that. So I think we can do what Mr. Harris is suggesting. I think it's just, they all responded to an officer in trouble, had one at gunpoint without saying that Sergeant Flores directed anybody to go in the house.
so I think that the state has actually misstated what actually happened. And what actually happened was that at 1:40, 50 or so, or actually before that, Rojas screamed out, "Watch out, watch out, watch out, watch out." And Melissa came running at him, swung the hammer twice at his head, and had Salinas not moved backwards, he would have been hit in the head, and he yelled out, "I have one at gunpoint, she has a hammer." So this misstatement that it was because of the candle is a repetitive misstatement by the state, and we should be allowed to get into what actually happened.
If I may, Your Honor, I had Officer Salinas on direct. I believe at that time on direct, he did testify that he called Sergeant Flores.
Yes, that's correct. I agree with that.
And his body cam, which is in evidence, starts with him passing on to Rojas. 300 said we can go in. That's already admitted into evidence.
300 said we can go get her.
Okay, go get her. And then through the windshield, through the window on the patio in the next statement, on an exhibit that is already in evidence.
Anything that is in evidence is in evidence. It's just Salinas testified, and then they attempted to impeach with Thornton. That was excluded because of the situation with Salinas by the court. And so we're just asking that not be an end around with this witness to go back to what that was.
Not intending to do that, Judge.
Understood.
All right.
Are you guys all right for the jury?
welcome back members of the jury. All right, where we last heard call.
Detective, as I recall before, we took a break. We were talking about what you observed when you got into the apartment. Who was there? What was going on when you got to the apartment?
The CSIs were in there processing evidence when I got there.
Okay. And Your Honor will move to publish State's Exhibit 150, which has already been admitted into evidence.
All right.
Pausing it right here. What is that collection of placards that are out there? What's there, if you recall?
Shell casings.
Is that what you talked about earlier?
Yes, sir.
Detective, you recognize the footage that was recorded from when you were out at the scene?
Yes, sir.
Did you have any instructions or directives to the evidence technicians that were collecting evidence and filming what you just published to the jury?
They were already doing it in the process of collecting everything, so I didn't give them much direction on that.
About how long were you out at the scene? You said you got there a little after 3?
I'm gonna estimate maybe an hour, less, maybe somewhere around an hour probably. Not sure.
Where did you go when you left the apartment complex?
I went back to police headquarters.
And what did you do when you got back to public safety headquarters?
After getting back, I think I met with one of my sergeants that were there. He instructed me that one of the officers were there. I think it was Officer Alejandro, and he told me that I was going to be taking his statement.
And what did you have to do to prepare to take the statement of Officer Alejandro?
I think they already had a room set up. It was one of the sergeant's rooms, sergeant's offices on the ag assault side of the office, and I had to go there and set up for the viewing for him to watch his body cam.
Okay. Did you know if his body camera footage had been downloaded by the time you were there?
Yeah, it was my understanding that they had already downloaded everything when they got there.
And they is who?
Oh, I'm sorry, the defendants.
All right. And so where did you go? What did you see?
I set up the room. I signed into the sergeant's computer, and I pulled up the body-worn camera under my name.
All right. And what did you do after pulling up? And whose body cam did you pull up?
It was Officer Alejandro.
Okay. As you were doing that, did he have any requests, demands? Did he want to see a counselor, therapist, doctor, anything?
No, I don't. He did not. No.
After you made his body cam footage available, what did you do?
I think he met with one of the cleat attorneys that was there. I told him whenever we're ready, we'll start. I can't remember if they had a brief meeting before. I'm thinking they did, but I'm not 100% sure. And then after that, went in there and then we started proceeding with the statement.
Well, I want to take it about that. So
Okay.
you set it up.
Okay.
He had support.
Yes.
Did you stay? Did you leave? What?
Usually I'll let them talk to the cleat attorney on their own for a few minutes.
All right.
So I might have walked away for a few minutes and then came back.
Could they play the video on their own?
That I can't remember. I don't know. I'm sorry. I can't. I had it set up, but I'm not sure if they were able to look at it at that time by themselves.
How long were you gone?
Maybe a few minutes. Just walked away for a few minutes.
Did they indicate that they were ready? Did you come back on your own, or did you
Yeah.
come back when they were ready?
No, I just came back to check, and then when I came back, they were ready to proceed.
And when you say proceed, what do you mean by proceeding?
Well, that's when I sit down. We turn on the video, and then we kind of start from the top about how this incident occurred.
And how does that process work? Are you asking questions? Does Officer Alejandro just start on a narrative? Please tell the jury how this works.
Yeah, usually I'll kind of I'll ask a few questions to kind of get us started, get us in the right direction of how he got out there, maybe what they were dispatched out there for, and usually on the header it'll be like it'll put information for him, how long he's been on the department, education level, things to that extent, and then we go into just he's on patrol, kind of start from that, where maybe what he was doing prior to the call, and we'll kind of go from there and just kind of work our way into when the incident happened.
Are you asking him questions, or is he talking to you in the narrative?
It's a combination of both. I mean, just once we get him started, the questions will go down. I won't ask as many questions. I kind of let him go. This is in his own words about what happened.
Okay. And how is this being documented? Is somebody writing it down longhand? What's happening?
So I'm actually typing up the statement as we go.
first witness here?
Yes.
Detective, I'm showing you what is marked as State's Exhibit 194 for identification. What is 194 for identification?
That is Officer Alejandro's type statement.
How do you know it's his statement?
His name's at the top, and he had signed it, and I'm signed here too, also.
Tender states 194 for identification, defense for inspection, move to introduce 194 for identification of evidence.
We would like for Nathaniel Villalobos' statement to be introduced as well under the rule of optional completeness, since all the officers are stating that they were justified in explaining the same event. And I believe under the rule 106, all of the statements should be introduced.
Yeah, Judge, we would join that and agree, obviously, on behalf of Nathaniel Villalobos, that we would be concerned if they entered in two of the officer's statement and didn't enter in Villalobos for optional.
I have marked State's Exhibit 195 for identification. That's what I understand to be the statement of Officer Villalobos. I tender 195 for identification to defense for inspection.
And
I have no objection to either.
we would like both to be introduced.
Yes, Your Honor. We have no objection to either exhibit.
All right, both 194 and 195 are admitted.
We proceed with one. Detective, I'm showing you what is introduced into evidence, State's Exhibit 194. And you recognize 194?
Yes, sir.
And it appears that you were, is that when you completed the statement?
Yes, sir.
All right. Why was Officer Alejandro dispatched to the apartments on Old Pearsall Road?
He was there for an officer in trouble.
He indicated there was a suspect wielding a hammer and had thrown a piece of glass at him.
Yes, sir.
Right? And if you would please go ahead and just read it by way of publishing.
Okay. On June 23rd, 2023, at approximately 1:41 hours, I began heading toward an officer in trouble. The details were an officer had a suspect at gunpoint and was wielding a hammer at 6200 Old Pearsall Road. The primary officer advised responding units that the suspect had just thrown a piece of glass at him. Upon arrival, I saw a group of officers standing outside the suspect's apartment. I remember asking one of the officers for an update on what was happening. One of the officers said that the suspect was inside the apartment with a hammer, and she had cut the fire alarm wires to the apartment complex. Then I looked past the officers and observed the suspect holding a hammer in her right hand behind a large TV at a large window with no screen or glass. The officers were standing outside the patio of the first floor apartment, outside the porch, guardrail. At this time, officers attempted to de-escalate the situation by convincing the suspect to surrender. After several minutes, officers were unsuccessful at convincing the suspect to surrender. Therefore, one of the officers jumped the guardrail to assess the situation better and get a better look into the apartment. I then heard a commotion of officers moving away from the railing and someone giving the suspect verbal commands. At that moment, I observed Officer Salinas unholster her weapon and point it toward the suspect, who was still inside the apartment. I was also made aware of another bedridden person inside the apartment. My concern was that the bedridden male was in danger due to the suspect's erratic behavior. I thought he might become a hostage to the female suspect. At the guardrail, Officer Thompson continued communicating with the suspect while other officers created a reaction plan. Because of my experience with the hostage negotiator team, I knew I could occupy the suspect's attention while the other officers implemented the reaction plan. I stood at the guardrail with Officer Thompson to my left while communicating with the suspect. Sergeant Flores told me to continue speaking with the suspect while he and Officer Villalobos jumped the porch guardrail. I unholstered my duty weapon for officer safety as they jumped the rail, knowing she had already attacked an officer. While Sergeant Flores and Officer Villalobos stood at the porch door near the back window, I observed the suspect turn and face towards them as she picked up a hammer in her right hand. I then saw the suspect rush towards the porch window where they were standing, and I observed the suspect wind her right hand in the air with the hammer in her right hand. Fearing the suspect would throw the hammer at Sergeant Flores and Officer Villalobos, I said, "Watch out," as I discharged my weapon several times. At this moment, the suspect took several steps backwards before attacking the officers at the porch window again. During the second attack, I shot at the suspect again and observed her still standing at the window. At the same time, Officer Villalobos and Sergeant Flores fired at the suspect simultaneously. Moments later, I didn't see the suspect standing at the porch window and observed Officer Villalobos force entry through the porch door. After Officer Villalobos made entry, I followed several of them inside to provide life-saving measures to the bleeding suspect. I then saw officers already providing life-saving measures to the suspect. A supervisor then instructed me to leave the scene and stay outside. I sequestered myself and I was transported to the homicide office to provide a statement. All officers were in full San Antonio Police Department uniforms and were driving San Antonio Police Department marked vehicles. I consulted with Cleat Attorney Bream and then spoke with Detective Soto about the incident. Everything I have said to Detective Soto is the truth, and I have read my statement, and it is correct. I was not promised anything for my statement, and I have given this statement freely and voluntarily. This incident occurred in San Antonio, Bexar County, Texas.
And do you know who took 195?
I believe that was Detective Carrion.
If you would, please.
Okay.
By way of accomplishment, go right ahead.
Okay. My name is Nathaniel Villalobos. I am currently assigned to South Patrol, and I was on duty today in full San Antonio Police Department uniform and in a marked San Antonio Police Department patrol vehicle. I had my body camera system and my patrol vehicle had active code-ban. I graduated the police department in August of 2020. I graduated high school in 2014 and have some college credit hours. I started my tour of duty at 1,700 hours and was assigned to 6361 Tango and was doubled up with 6351 Tango. Officer T. Thompson. I was on a call at Southwest Military in Five Palms, and my partner told me about officers with a suspect at gunpoint in trouble. Officer Thompson asked me if I heard the call. I told him I did not. I think Officer Thompson stated an officer had glass thrown at him. Officer Thompson and I diverted from the call we were assigned to and started toward the direction of the officer in trouble. Officer Thompson drove to the call. The call was off Old Pearsall Road and was a few minutes from our location. We drove to Old Pearsall Road using our patrol vehicle emergency lights and siren. We arrived at the apartment complex and I observed several marked patrol vehicles. I exited our vehicle and moved toward the direction of the officers on scene. I observed uniformed officers standing outside a patio to a downstairs apartment. I contacted an officer at the scene, and that officer told me that someone threw a glass candle at one of the officers. Another officer stated that an officer was struck with a glass candle but was okay. I did not recall the name of the officers who provided me the information. I moved toward the railing of the patio and observed a white female standing standing in the living room of the apartment. The female was wearing a white muscle shirt, had a shaved head, and was holding a hammer in her hand. The female was walking back and forth in the apartment and talking loudly. I could hear the female state, "We can't go inside, we need a warrant." The female stated we were disrespecting her house, and she continued moving back and forth inside the apartment. The female appeared to be aggressive, confident, and belligerent. The female had the hammer at her side, and it had an orange in color handle. I observed the window open with no screen or glass to the apartment and decided to communicate with the female. I asked the female, "Why are we here? Why are we out here?" "Why are we out here tonight? What is going on?" The female continued to repeat, "We needed a warrant and were disrespecting her apartment several times and did not answer my question." I could not see anyone else in the apartment. I told the female she injured an officer and we would come get her. I asked the female if she would step out of the apartment peacefully or if we needed to come in. The female stated we would need a warrant. Officer Thompson came to my left side and began to speak with the female. The female continued to repeat, "We need a warrant and we're disrespecting her house." Officer Thompson asked the female to come outside. The female did not comply. The female moved inside the apartment and I lost visual of her. I moved onto the patio of the apartment and checked if the patio door was locked. The door was locked and I could not see the female. I placed my arm into the open window and was able to reach and unlock the patio door. I was partially inside the window as I moved back from unlocking the deadbolt. I heard Officer Gomez and Officer Salinas state the female was coming back into the living room and was headed toward my direction with the hammer. I could not see the female. I unholstered my weapon, fearing the female could attack me with the hammer. I pointed my weapon at the door and could not see the female. I heard the female state, "We needed a warrant and were disrespecting her house." I reholstered my duty weapon and moved or jumped from the patio back to the other side of the railing. I observed the female inside the apartment, standing next to the window. Officer Thompson spoke with the female for a few minutes and I decided to move from the location to speak with a supervisor regarding the situation to inform him I had been able to unlock the door. I spoke with Sergeant Flores, who was a few feet from the apartment. I told Sergeant Flores I was able to unlock the patio door, and he told me to stand by. Sergeant Flores stated another supervisor was getting less lethal to the scene. I moved back to the patio where Officer Thompson was talking with the female inside the apartment. The female continued to repeat herself and was not complying with our verbal commands. Officer Eleazar Alejandro came up to the patio area where Officer Thompson and I were staged. Officer Alejandro asked the female if we got a warrant, would she come out and talk to us. The female stated, "You need a warrant," and refused to come outside. We continued to speak with the female for a few minutes, with her refusing to comply. Our conversation with the female was not going anywhere, and I decided to move locations. I moved to speak with Sergeant Flores, and he told me a team was going to be entering the apartment soon. Sergeant Flores stated a team would be entering the apartment from an open window separate from the window where we were positioned. Sergeant Flores stated I needed to keep communicating with the female and keep her attention. I moved back to the apartment and jumped onto the patio. I could see the female in the living room as officers continued to speak with her. I could see the female looking at my direction as I jumped the railing, so I unholstered my taser after I landed on the patio. I lost sight of the female once I jumped onto the patio. I had the taser in the low ready position, and I moved to check on the door. I moved the door handle, trying to open it, and it was locked, which surprised me as I thought I had unlocked it. At about the same time I tried to open the door, I heard gunshots coming from behind me. I could not see who was firing. I moved away from the gunshots, which were coming from my left side. I moved toward my right and positioned myself against the wall. I observed the female in the living room through the door. She was standing up, holding the hammer. The female appeared as if nothing happened. I moved toward the patio door to open the door handle with Sergeant Flores behind me. Sergeant Flores Sergeant Flores moved me toward my left and I could see the female. As I moved toward the patio door, the female was sprinting directly toward me with a hammer. The female was a few feet away from reaching the patio door, and I moved backwards to create space. I lost sight of the female and I holstered my duty weapon. I had my taser in my support hand. I thought the female was about to exit the apartment and attack us with a hammer. I thought the female would exit the apartment at any time, and due to limited space, I was not able to move. I thought the female was on the other side of the wall, and I fired 3 shots where she would have been positioned. I heard an officer state the female was down. I kicked the patio door and broke the glass. I observed the female on the ground. I placed my arm through the door to inside the apartment and unlocked a second deadbolt. I opened the patio door and entered the apartment first. I observed the female bleeding on the floor and she was conscious. I moved to the female and began emergency aid. An officer handcuffed the female and I began to apply life-saving measures. I moved to my patrol vehicle to get medical supplies and returned to provide aid on the female. I was instructed to move from the scene as other officers provided emergency aid. I remained at the scene until I was instructed to give a statement at the homicide office. Officer Andrade gave me a ride to the homicide office to provide a statement. This concludes my actions in this statement.
So at the time you took the statement from Officer Alejandro, did he have an opportunity to stop, review his body camera if he was unsure of anything?
Object to the characterization, unsure, it's cause for state of mind.
Well, also, Your Honor, we would also object that this witness, as far as, are you referring to Villalobos?
Alejandro.
There.
Was this all one setting or was it iterative? Did he stop, review? Did he have the opportunity is what I'm asking?
Talking about Alejandro.
To compound and bake.
Did you write Officer Alejandro's statements 2 pages?
I did Officer Alejandro's statement, yes.
Yes. Was it, those 2 pages, was it all in one setting? Did he just work, you kept up? Or did he stop? Go back?
So the way I remember it is we went through, we finished it, and then it's not just like all in one thing, like we have to go, we take it to the sergeants, we take it to the captains, they review it, usually for like punctuation, stuff like that. And then we bring it back to them, and they get to make sure that, they fix it the way they want the statement to look.
Did he ask to see his camera again once he started reviewing the statement?
We watched the body-worn camera. I honestly, sir, I can't recall if he did ask. I don't know. I can't remember.
All right. Who or what is CLEAT?
They're attorneys. They're attorneys that work with officers in situations like this.
And how did they know to show up?
They're notified usually by the shooting team command staff. Someone will call them and let them know, and they usually go straight to headquarters.
Okay. And so that process you described. So before the statement's signed, it's shown up the chain of command.
Yes, the captain and sergeants and lieutenant will read them. Yes, sir.
Do you recall if the chain had any other questions for Officer Alejandro?
I can't recall exactly, no, sir.
Ultimately, he signed what has now been admitted to evidence as States 194.
Yes, sir.
After you had the statement, then what did you do in your investigation?
At that point, after the statement was complete, I'm working with other detectives We work as a collaborative unit there, especially in an officer-involved shooting like this. There's a lot of people there, a lot of detectives there, captain, sergeant, right? And all the officers, all the witness officers are there. It's a closed office to the public. Nobody can come in there. No other officers can come in there, like civilians can come in there. We have it closed off. And in this particular event, I mean, there was a lot of people involved in this. So at that point, I'm talking to different detectives. It was kind of chaotic because of all the people that were there in the office. And I'm just meeting with different detectives. They're coming to me, showing me things, showing me body-worn camera footage from some of the people that they talked to and officers they took statements from.
Did you have to leave public safety headquarters to do anything?
Eventually, I did later on in the morning.
What did you have to do?
Before I left, I received a call from, I can't remember, I think it was one of Melissa's sisters. I don't know exactly who. And I think it could have been Alexis Tovar, her daughter, I'm not sure. But I received a call, spoke with them briefly on the phone. They were concerned that they believe this incident involved their sister and mother. I didn't want to give them too much information on the phone, but asked them if we could meet up later that morning.
And did you actually go and meet up?
Yes, sir, I did. We did meet up.
Who did you meet up with?
I met with Melissa's daughter, Alexis, and I think two of Melissa's sisters and one of her brother-in-laws. I don't have their names off the top of my head.
Do you recall meeting with a Daisy Nieto?
I'd have to look at my report, I'm not sure.
Please, open it up and refresh. Recommend you looked at about page 47 or thereafter. I may be wrong. Detective will move on from that. What is the purpose of meeting with that family, though?
Usually it's we do every time we have a homicide or someone dies, we even for suicides, we'll do a next of kin notification, try to find the family, let them know, that their loved one has passed as soon as possible. It's one of the priorities that we want to get done on almost all of our cases.
Does the department have any particular or special considerations when there's an officer-involved shooting that results in death?
Well, yeah, it's kind of heightened. This is something that's prioritized. That they want us to get that done. Yes, sir.
Okay. Does that involve or entail any different considerations in a normal homicide when it's an officer-involved shooting?
No, I mean it was just I think an officer-involved shooting, it's just, we have a lot of people looking at the case, a lot of the brass are there, they're looking down on everything, and it's just something that they probably want prioritized. But normally in any case, when I get a suicide, I'm looking for the family right away, trying to make a notification, especially if you have a positive ID on somebody.
You know how long you met with Ms. Perez's daughter, Alexis Tovar?
I'm going to estimate maybe 20, 30 minutes. It could be longer, it could be shorter. Around that time, it was about 20, 30 minute conversation.
Was it, did you meet with them at their home or was it down at headquarters?
It was, I think it was at one of the aunts' houses. It wasn't where Alexis lives, I know that.
Did you invite her daughter to do anything else while you were there talking to her at the home?
Yeah, after we were done, it was requested by me to ask them if the daughter wanted to see the body-worn footage of the incident.
Did she?
Yes, she did. And an appointment was made for later on that afternoon.
Did you relay that appointment to Ms. Tovar?
Yes, I did. It was actually we confirmed the time later on. Once I got with the captain and sergeants to make sure they were available at that time, we were able to. I think I called her later on and told her, "Hey, we're going to do it this time," and she agreed at that time.
Were you a part of that meeting where Ms. Tovar viewed body camera footage?
No, sir. One of my coworkers, Detective Dorsey, stood in for me on that.
What were you doing while they were looking at the body cam footage?
I was actually at that time. I was working on the warrants at that time. When they were looking at the footage around 3 o'clock.
Yes, sir.
Yes, I was already. We were working on the warrants. Yeah.
Why were you doing that?
After a meeting with the captain, Captain Van Geffen, we discussed the case. This was around maybe 2:30ish, maybe a little later, around that time. The reason I recall it because it was before the appointment for Ms. Tovar to see the footage. So met with Captain. We discussed the case. I don't think any of the sergeants were there. It was just me and him. And we came to a mutual agreement that there was probable cause in this case to move forward.
Okay. Now, to reach that decision, what had you yourself done besides taking Officer Alejandro's statement?
Right. Watched body cam footage from the 3 defendants, other officers that were there near the crime scene, near the scene, the porch area, and read the statements of the other officers.
You said you watched whose body cam footage did you watch?
The defendants, Sergeant Flores, Eleazar, and Villalobos.
And if you could could you identify Defendant Flores?
Yes, sir.
Point him out, identify the article of clothing he's wearing.
Yes, sir. He's wearing a gray suit and a gray tie. He just stood up.
And could you identify Defendant Alejandro?
Yes, sir. He's wearing a black jacket with a tie.
And could you
glasses.
identify?
It's in blue, sir.
And could you identify Defendant Villalobos?
Yes, sir. He's wearing a blue jacket with a red tie.
And for the record, Your Honor, the witnesses identified the defendants. Now, so you remember about what time you went to see Ms. Tovar and her family?
I'm going to say it was around 9 o'clock, maybe? Around that? No, I'm sorry. Maybe around noon. I think it was around noon.
Yes. And about how long did you stay there?
Maybe 30 minutes, maybe. Yeah.
So you're back in your office about 1 o'clock?
Yeah, probably around that time, maybe a little before.
And is that when you restate again what you did when you got back?
Started reading more statements, looking at more body cam footage of the incident.
And you remember previously, I'd asked you what your initial observations were out at the apartment.
Yeah, initially I had concerns just because of the placement of the shell casings and Ms. Perez being inside the apartment.
So the work you did, the tasks you went through once you got back from the visit, did you pursue those concerns when you got back with the body cam?
Yes, I did.
And I believe you said earlier that you got back and you discussed with the captain. Who is the captain?
Captain Van Geffen.
Judge, can I just have a clarification? What time was that? Because I'm getting confused on the AM and PM. The meeting with Van Geffen.
Okay.
Oh, I'm sorry. I'm estimating it was like around 2:30 p.m. Yeah, I'm sorry, sir. Yeah.
And this is also, what day is this?
This is on the 23rd,
So
Friday.
do you said you looked at all of the body cam for all of the defendants?
Yes. Throughout the morning, like I said, after we were done, I was done taking Eleazar's statement. I'm contacting other detectives. Like I said, I wanted to paint a picture for you guys. It was a lot of people there, a lot of stuff going on, and the office was somber. This wasn't easy. These are officers that I've worked with, I've seen out there on the streets. I remember them going to scenes. Like this was tough. It wasn't.
Your Honor, I'm just object. It was real easy for him. He did it in 16 hours, so it was super easy. The investigation was easy, so I'm going to object to that characterization.
Overruled.
So yeah, it was just going through the day, really hectic, watching video, just trying to get this done, trying to watch as much as we can until I develop probable cause for the case.
At this time, I move to publish what has already been admitted into evidence as State's Exhibit 2.
Yes.
Which is the body-worn camera footage for defendant Alejandro. And yes. For the record, Your Honor, we're sitting at timestamp 0135, and we're going to advance it to 014404. Timestamp 014554, and we will advance to 015026.
Yeah? You're gonna stick around?
No, I got house calls.
Oh, sure.
That was the closest.
Have fun, bro. We miss you. It's this apartment, right? 3102?
Yeah, I think it was down. So down.
Just get back. Just hold what you got, Maria. Villalobos, are you able to jump back? No, because we can't get there. There's no point in saying it.
I'm gonna give the maintenance guy real quick before we go over and grab it, alright? Who's that shield?
Jump now. Now! Jesus, guy. There's no point in tasing him, bro, because how are we gonna go hands on?
Yeah,
Oh, the door's unlocked?
That's what I was telling you.
Sergeant always unlocked?
I was trying to tell him that. What door's unlocked?
This door's unlocked.
You unlock it?
Yes, it's unlocked. Let me look at him. I don't think he knows it's unlocked. The ramp?
No shield. Just in case.
That door is unlocked, Sarge. This door right here is unlocked.
Yeah, but that door's locked. This is open. We've got another window. There's a window also on the side that's a back bedroom that she hasn't gone near. I mean, I've already got the screen off that. I would definitely deal with this. You can screen off too. Maybe we'll come in behind her.
But we have to pray on good contact. We have to pray on good.
Well, that's what I'm saying. But she has. But if it doesn't make good contact, bro, we can just keep the foot on the door. She won't come out. That's what I'm saying. And if we see her drop, dude, get in there.
Something I would have yeah, that makes sense.
There's one in the other. Oh shit.
Yeah.
You don't have a shotgun? You carry like 10 Shotgun. That's legal. You have an ass, Sarge? He's got one. There it is, bro. Let's go right here, sir. Villalobos, is this one right? How did you reach? Oh, he's tall as hell.
She's not all alone, right?
No, it's a bedroom.
Let's wait for Sergeant to take these last people. And we'll go into the shield, be contact her, keep communicating with her. And she has that, if she has a hammer, sir, we do what we have to do. Hopefully we can get started with use the testigo or being back to council. So this one goes with the girls. This one.
This last one?
305 is in one. 305 is in one.
This is.
Then there are.
What's your name? I wasn't here, so what's your name? We're asking you.
I hate the one who's being harassed across
Can you please just cut off so we don't have to use force or anything like that?
No.
Detective Soto, do you recognize the voice that just asked Ms. Perez that last question?
Yeah, Officer Villalobos.
Thank you, sir. And the other officer that is up front at the railing before Officer Villalobos asked his question, do you know who that is?
I believe that's Officer Thompson.
And from your knowledge, I'm showing you what is states, in evidence it states 195. That Officer Thompson you just identified in the body cam, is that the same officer that Officer Villalobos put in his statement he was doubled up with this night?
Yes, sir.
Because I already know what's gonna happen.
And so if it's gonna happen regardless, what's gonna happen easier?
What's gonna happen? Tell us what is gonna happen.
Like previously, I've been arrested on false accusations. I'm not having it anymore.
This isn't false. Here's something
This
you
is
didn't
false
know.
accusations and you came and tore my door down.
Okay. Okay. We're trying to be very patient with you and very
If you want to be conventional, you respect that elderly man that I picked up from the street, and you respect my property, and you respect my apartment.
We are trying to. If you would just come out, then your apartment, nothing's gonna happen to it.
You want me to come out so you can arrest me?
Well, it's either you come out and we arrest you, or we go in and we arrest you.
Well, I'm not, you know what? I'm not going that way. I'm not going 45 days again for false accusations because I think they've done that 3 times.
Okay. All right. Well, like I said, we try to do this very peacefully.
You need a warrant.
No, we don't.
You ain't got a warrant.
I promise you I don't.
So if we had a warrant, you come out peacefully?
If you had a warrant, let the judge give you a warrant.
Okay, so hold on. So hypothetically, if we had a warrant, would you?
You need a warrant. Don't act stupid.
Well, that's what I'm saying. What if we had one? Would you come outside?
You don't have a warrant.
Okay, but if we had one,
If we had one.
If you had a warrant for what?
So the warrant matters now, huh? So now,
Exactly. You don't even know for what.
does it
For
matter?
what? And a warrant for what? Explain to me. You're the officer, right?
You seem to know more than me. You seem to know more than me, so you tell me what the warrants would be for.
No, you're the one who's harassing me, so you tell me what the warrant
I
for.
just got here. I just
Yeah,
got
we're
here.
good. Look, hey, we're just trying to help you.
You're not helping me because you're harassing me.
How are we harassing you?
Because you're shining the lights, kicking my door down.
Are you sure that was me?
That was the other gentleman. They kicked my door down, knocked my picture down.
Is your door kicked down right now, though?
They kicked it down. They tore down pictures and they tore off the screen.
If it was kicked down, we'd be inside. Well, don't you think that makes sense?
Don't act stupid because you know what?
I'm
That's
not.
not rolling.
What's rolling?
That's ridiculous.
What's
Don't
rolling?
embarrass yourself, sir.
I'm asking you what's rolling.
The camera.
What
There's
camera?
cameras rolling, trust me.
What cameras?
There's cameras rolling.
Where? Tell me where they're at.
Especially for the officer who took down my door.
Well, tell me where they're at so we can make sure we get that as evidence.
I have plenty of evidence.
Exactly. And now we'd like to see that because if we're in the wrong. Okay, so if we have all this evidence.
Hold on.
You ain't got a warrant.
Get up.
She's down.
Yeah, I'm good. Okay? Yeah, I'm good.
Hey, Stardust, hey, get some medical stuff.
Hold on, let me get up there.
it's on her legs and her arms. If she, yeah, well, let's find out where that blood's coming from. Hey, hey, hold on, hey, bro, just cut it over. Yeah, cut it over. Yeah, cut it over. Cut it over. I have my hands moving. Did you shoot? You good, man? Yes, I'm good. Hey, you good? You good, me? Yeah, I'm good. Let's make sure her legs aren't bleeding. Yeah. Can someone play that taser? Did you fire?
No, I didn't fire. It was just you and the sergeant.
Okay. You wanna know me? Yeah. I'm almost in my car side. That works?
Why don't you clear your front? Where's your car?
Oh, over here.
Clear your front.
Mine has my negotiator stuff in it, so I'm gonna have to take my car.
Okay, then clear your front seat.
Okay, so she can come with me.
Yeah,
all right, yeah. Oh, my car's right here, Maria. Are you able to get back here? What? Your car back here? No, it's all there. Okay. So you want me to move? Are you? Oh, you can just bring your stuff. Whatever you want. Yeah, let me just get my stuff out of here, and then you can bring it right back here.
State's Exhibit 2 is finished playing, and for the record, I'd like to go back to timestamp approximately 01:53:50.
Just in case. Oh yeah. That's what I'm saying. But if it doesn't keep, that's what I'm saying. Yeah.
And do you identify the name? Can you identify the female officer that just spoke?
Officer Maria Salinas.
Yeah, that makes sense.
It's crazy, bro.
Can you identify whose voice it was that said approximately 01:53:55 chicks crazy, bro? You identify that
Can you go back to that? I'm sorry. Yeah.
You threw something at one of our other military. Yeah, that makes sense.
It's crazy, bro.
I believe that's Officer Alejandro.
See?
You should do that for yourself. You ain't got no warrant. You're not my doorbell. Or my kids, my gates, my people. There's one in there, right? A guy's in it?
Oh shit.
Yeah. You ain't got a warrant.
And could you restate what you heard, the conversation between Officer Maria Salinas and right before, what did Officer Maria Salinas say?
I think they were telling him that there's somebody inside.
And what was Officer Alejandro's reaction to that?
He was just, oh shit, we have to go in.
From your recollection of playing the rest of State's Exhibit 2, did Officer Alejandro do anything with that information after explaining we have to go in? Did he relay that to anyone?
No, he didn't tell anybody, never went to check on him. I never heard any more conversation about Mr. Santos.
And so by way of your answer, you understand that there's one in there, and he said we have to go in, is referring to the person Santos de la Rosa.
Yes, sir, Santos de la Rosa, her roommate.
The state would move to publish what has been admitted into evidence as State's Exhibit 3.
Yes.
Which would be the body-worn camera footage for Officer Villalobos. For the record, Your Honor, the body cam footage started at about 01:38:30, and I wish to advance it to approximately 01:42:25.
As you go in, you take a nap. Once you're sober enough to do whatever you need to do, send you on your way. It's literally just hangs out there. That's all it is.
Hey, Mark, you listening to your radio?
No, what's up?
Rick Williams got one. He's looking for you. He's not too far, and he just said somebody hit him with that. Hey, look, man, stay out of the street. Okay?
All right, get on, man. Let's go. Sorry about that.
People that are coming.
Your Honor, I am pausing at timestamp 01:43:14 and will advance it to 01:44:10.
Show me 340. I'm telling you. Because he said on Pearsall. Is this on Pearsall? Yes. And is this where they're at?
Officer over the radio said, slow it down, contained inside the apartment.
Yes, I heard the dispatcher say that. Yes, sir.
The dispatcher said it, and then did you hear Officer Villalobos repeat, contained inside the apartment?
Yes.
He was
approximate timestamp 01:44:49 and advance to approximately 01:47:01. Play.
You're gonna continue on down.
Breathe. Melissa, come back to us. Yes, sir? So, I guess we'll start the meeting,
And Detective, do you recognize the voice of the officer that's talking right now, the one Officer Villalobos is speaking to?
I believe that's Officer Rojas. Rojas?
Sorry. Hit up on the wire for the. What's her name? Melissa? Right? Yeah. She's the one here? No, there's an old man over here, like, you're gonna go, you're kicking the door, you know.
Come on, talk to me. You got a rail? Can't you talk to me right here? What's going on? What? So you're not gonna come talk to me? Why not? Why not? Why not? You don't want to talk to me? Come outside. You can talk to me right here. I can't do nothing about it right here. Come talk to me.
Everybody's watching you all of America.
Melissa, come out here and talk to us.
Okay, yes,
I know, but she's right there. Is anything said I can't get it? No, we tried to kick out the door. I'll try to fucking window. We tried that. She started throwing it. Like, she told me that and she had to grab the hammer. You got a hammer.
And for the record, I'm pausing at 01:49:16, and I'd like to back it up approximately 10 seconds.
Tried to kick out the door. I'll try to fucking window. We tried that. She started throwing it. Like, she told me that and she had to grab the hammer.
And did you hear Defendant Villalobos say, "Why don't we just try the window?"
Yes.
And what was the response he was given from an officer? I can't tell who it is.
He said we tried, that we should grab the hammer.
You got a hammer. Where's Thompson? You have shield in the guy. You judge it?
Yeah, you're harassing me and my department. Look at all of you guys, you look ridiculous.
Pretty good to go much
But you're harassing me and my company. Ma'am, you wanna talk to me? No, I'm not talking to nobody. You need to leave and give us some peace because everybody's watching you. Everybody's watching you on camera around the world, on national TV. You jumped that? That's fine. You're done. That's fine. Everybody watches us. Everybody watches us, man. They're watching us. All right, whatever you do. Let's say they want to pour my door down and shine the light and get up in the back and I open it up. That's fine. All right. And they got my screen. Exactly. Okay. So you're harassing me.
Sergeant Flores, Sergeant Police, are you gonna make things more difficult, or are you?
No, I didn't make them difficult. Do you have a word, Sergeant Flores? Do you have a word?
What I'm asking you, are you gonna come out for us?
Do you have a word?
I'm gonna negotiate.
No,
Just get back. Can you talk to me?
You're trespassing, you ain't gotta work. You ain't gotta work. Point me out, give a fuck, you ain't gotta work.
I was trying to tell him that. Yes, it's unlocked.
You ain't gotta work, you ain't gotta do
Doors unlocked, sir.
Take my door out, but don't work.
She almost drowned.
God bless you, but you know what, you're very wrong. Like the Bible is doing, before you were wrong.
But if it doesn't make good contact, we can just put on the door. Yeah, and then that's when if you
You come in knock on my door, and throw the door down without warrant, that's a disrespect.
Yeah, you threw something at one of our officers. Yeah, that makes sense.
It's crazy, bro. Let's just.
You should do that for yourself, honey.
You guys.
Dude, I
thought you were let's go.
There's one in there, right? A guy or something?
Guys got rid.
Oh, okay.
Oh shit.
Yeah.
Does anybody got Sorry, John. Reach to the window and unlock it. She's on the road, right? No, she's got, there's somebody in there. She's in the front though, she came right at me, so. Let's wait for Sergeant we'll go in with Sheila, so be a contact person to keep communicating with her. And she said, if she hasn't handled her, we have to be, we can get started using what she will, this one is really control. No, this one is. This is going to be a little bit, okay? What's her name? What's her name? What's your name? I wasn't here, so what's your name?
My name is Melissa Perez. My name is the one who's being harassed all across America.
Miss Perez, you don't want to come on and talk to me?
No, because I'm going to get arrested because I already know the way it works.
Okay, so you know that you're going to get arrested.
But no, they put my door down without no work.
So?
Put my window down without no No, it's all good. And I'm not having that false accusation again.
So let me talk to you about this, okay? No matter what happened, okay? Whether they kicked the door in, whatever happened, okay? No, but listen. I don't, but listen. But listen, okay? It doesn't negate the fact. It doesn't negate the fact. Okay.
Listen to me what I'm telling you.
I heard what you had to say.
I'm being harassed by every man that I picked up on the street.
Okay. So if you get what I'm saying.
And
you should have told us that we don't want to give, so we want it's like battery. Bring her. So she don't got the hammer on her right now? Yeah, right. If I hop over and walk her, if she stays there without me to cut the hammer, the door's unlocked. Yeah, they just wait for someone to get here with us. Let's say well, that was the case, I could just open the door and grab her. She doesn't go for the hammer right away. I can just go and tap her. It's on the couch. It's a good delay from her. She won't have enough time to get it if she stays at the door. But whatever you want. I'm just saying I can get her from opening the door. And we knew it was something because I didn't lock it. Okay, yeah. So I'm asking you to come out and I was able to reach in, I was able to unlock it. Okay.
I don't need to talk to someone who's starting my door down and harassing me and yelling.
Well, I didn't take your door down. I just
telling you somebody in his face along with mine and then turning the screen door. That's harassment. By the police.
So would you like to come out and talk to us?
No.
Are you going to make us go in?
You're gonna want to.
I've already said that.
I'm not explaining to you.
Well, like I said, one way or another, what's going to happen is going to happen, okay? I'm trying to explain the law to you so that this doesn't go, so that this doesn't escalate.
So before this has to get complicated, can you please just come out so we don't have to use force or anything like that?
No.
Why not?
Because I already know what's gonna happen.
And so it's going to happen regardless. What's going to happen here? What's going to happen? Tell us what is going to happen.
Like previously I've been arrested on false accusations.
Okay.
I'm not having it anymore.
This isn't false. You threw something and hit it on the officer.
Accusations because you came to throw my door down.
Okay. Okay.
We're trying to be very patient with you and very cordial.
Conventional. You respect that elderly man that I picked up on the street. And you respect my property and you respect my apartment.
We are trying to. If you would just come out, then your apartment, nothing's going to happen to it.
You want me to come out so you can arrest me?
Well, it's either you come out and we arrest you or we go in and we arrest you.
Well, you know what? I'm not going that way. I'm not going 45 days again for false accusations because I've been there, done that 3 times.
Okay. All right, well, like I said, we try to do this very peacefully.
You need a warrant.
No, we don't.
You ain't got a warrant.
I promise you I don't.
So if we had a warrant, you come out peacefully?
If you had a warrant,
You
then
come
I'm
out.
gonna give you a warrant.
Okay, so hold on. Hypothetically, if we had a warrant, would
You need a warrant. Don't act stupid.
That's what I'm saying. What if we had one? Would you come outside?
You don't have a warrant.
Okay, but if we had one. If we had one.
If you had a warrant for what?
It's just okay.
If you had a warrant for what?
So now,
Exactly. You don't even know for what.
does it matter?
And a warrant for what? Explain to me you're the officer, right?
You seem to know more than me. You seem to know more than me, so you tell me what the warrant is for.
No, you're the one who's arresting me, so you tell me what the warrant is for.
I just got here. I just got here.
Look, hey, we're just trying to help you.
You're not helping me because you're harassing me.
How are we harassing you?
Because you're saying that I'm kicking my door down.
Are you sure that was me?
That was the other gentleman. They kicked my door down.
Is your door kicked down right now, though?
They kicked it down. They tore down pictures and they tore out the screen.
If it was kicked down, we would get inside. It would make sense.
You know what? That's ridiculous.
I'm asking you what's wrong. What camera?
There's cameras rolling.
Where? Tell me where they're at. Well, tell me where they're at so we can make sure we get that evidence.
I got plenty of evidence.
Exactly, and now we got to see that because we're in the wrong. Camera down.
There's a guy in the bed over there.
Where's she at?
Hey, Flores, hey, give us some medical stuff. Is he messing with you? I know she's seen the shoulder somewhere. I see an injury where it looks like the top of the back. If she, yeah, let's find out where that blood's coming from. Hey, good. Hey, bro, just cut it off. Yeah, cut it off. Yeah, cut it off.
I am, I'm moving it. Are you good? You good? Yeah, I'm good.
Let's make sure we're
Yeah. Trying to find out where this blood is coming from.
Roll over.
Right here, I got a wound right here. Top of the back. I might have to get a chest seal or something like that.
Yeah.
Hey, please, come on, scissors. All right, right here to the chest. I got one under the arm as well, it looks like. Yeah, she's bleeding from underneath the armpit. Where's the packing? I don't even know whose this is.
Yes, I was.
Alright, bro, this is gonna go underneath her armpit. Let's see if we can pack them. Just open the chest and put that on her breast. Or her chest. Hey, bro, this is gonna get caught. Bro, this is a walking dog. Here, bro, chest seal here? Where? Chest seal right here in the back, and then we're gonna put one on her front.
Okay. One time. Come on, fucking team.
Take a deep breath. So I know we got one under the armpit. We just put a chest seal on the one on the back, and then she's gonna have one. It looks like it next to her breast, through her front breast. Looks like it's gonna be next to this one.
Any weapons on?
No, I think we got rid of everything there.
Yeah, fucking water faucet hits over here.
I don't think we did. Is that a chest suit? I don't know, that's not what that is. What was you?
It's alright, it's supposed to fall out. It's just coming in. Yeah, you gotta have a roll. Yeah. What's the need? He's borrowed. I did too. Right here. Yeah, I'm good. Yeah. Yes, sir. I got him, I got you, brother. Clear your front seat. Let's still front. Yes, sir. 230 clear with Thompson. Yeah, take a seat. Or on the passenger side. There was 3 locks on it. So the one that I originally had unlocked, there was one above that one too. So when I kept pulling it, she...
Members of the jury, it's 5:22. We're going to go ahead and break for the day. We cleared our docket for tomorrow, so be here no later than 9:15. We'll go through the entire day. All right, we'll see you tomorrow.
All right, for the jury